In respectful presence of our brothers and sisters across boundaries and faiths, let us all join in prayer and worship and gratitude and for guidance. Almighty and eternal God, we thank you for the gift of life and all its joys. We thank you for today, for all its challenges, in all its splendor. We thank you for the gift of one another. O God of infinite mercy and wisdom, only in unity with your will can all our toils have true meaning. Transform us into willing and able stewards of this world and its future. Bring us together to work with understanding and compassion. As we toil and grow weary, we pray for renewed strength and resolve. As we experience pain and sorrow, let us be reminded of untold good beyond. As we see pain and suffering, let us be instruments of your peace and extensions of your loving and healing hands. As we gather here today, bless us all that our collective knowledge be tempered and guided by your wisdom. Grant us clarity of vision to see the common good amidst all distractions. Endow us with humility and purity of heart to transcend all differences and reservations. When we leave this gathering, let us be the change we seek. As we endeavor to practice what we learn, let us be the good we want to see in others. As we work for our learners and their future, let it be that your will be done. In solemn silence, let us conclude with our own personal prayer.
Mga kababayan, ang pambansang awit ng Pilipinas. Kayang magiliw, telas ng sigatanan, alam ng puso, sa dikit mo'y buhay. Lupang hinirang, tuyag ka ng magiting, sa manlulupin, di ka pasisigiw, sa nagagang tutok sa simoy at sa langit mo pangaw, ay hinatang tulad awit sa paglayang minamahal. Ang isang ng matawad mo'y tagumpay na nagtitingin, ang bituin at araw niya kailan pang ay di magtitingin. Luman ang araw ng warhabit pagsinta, buhay langit sa piling mo. Ang hindi kaya ng kartay mga amin, ang mamatay ng dahil sa'yo.
Good morning to everybody watching our stream over on Facebook Live. I'm Regina, and I am your host for PALS Free Week, the frequently asked topics on the bar subjects. Welcome to our dear deans, speaker, professors, and partakers tuning into our stream. Day 3 of the 2022 bar examination has passed, and we're down to our last day of the exams on Sunday. Konting-konti na lang, you guys got this. This is the 6th lecture from the series, and we're very excited as we continue to help our barristers prepare for their exams. For this morning, we will answer the FAQs on remedial law to accompany what you already know. The PALS Free Week Frequently Asked Topics on the Bar Subjects lecture series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Rex Educampion. To know more about our event partners, let's all watch this video. Okay. Or we have. Okay, it seems like, are we having technical difficulties? Okay, so it seems like we don't have the AVP at the moment, so we'll get to that in a bit. So today's program aims to determine the most frequently asked questions for remedial law. These FAQs will be determined and answered by a distinguished guest this morning, and they have prepared a lecture to help the bar takers as they take the exam of their life. To introduce today's speaker, Dean Salvador N. Moya II received his Bachelor of Science in Commerce, major in Accounting from the University of Santo Tomas, and soon after his Bachelor of Laws from San Sebastian College, Recoletos. He also took his Master of Laws from the Pamantasan ng Lungsod ng Manila Graduate School of Law, and had recently accomplished his Doctor of Civil Law from the University of Santo Tomas Graduate School of Law, receiving Emeritus on his dissertation titled Critical Analysis of Criminal Appeals to the Philippine Supreme Court, Basis for Procedural Uniformity Framework. Dean Salvador Moya II has also authored numerous law books that is being referenced to by students and lawyers alike. He has also received awards and recognitions for his contributions to the academe and the legal profession. Currently, Dean Salvador Moya II is a managing partner at Moya Ablola, a Barlil law firm in Quezon City, a bar reviewer, a mandatory continuing legal education lecturer, a professor of law at numerous colleges inside and outside of Metro Manila, and the founding dean of Tomas Claudio College's College of Law. Without further ado, let's all welcome this morning's lecturer, Dean Salvador N. Moya II.
Okay, good morning everyone. I was tasked to conduct a lecture at 240 kilometers per hour because this is remedial law. So it comprises, based on the syllabus of the 2022 bar exam, general principles. We have jurisdiction. You have rule 1 to 71. Then we have also rule 72 up to 109, 110 to 127. And 128 up to 133. So I will try my best na makapture natin as much as possible. Pero unahin ko muna, maraming nagre-request kasi from reviewees and even some new lawyers, maraming nagre-request ng Moya 3. So dito, makakakuha siguro tayo mga 5 tanong. So at least makapag-contribute ako sa pagiging abogado o abogada ninyo. I will share the screen. Paki-share mo. Please call my attention kung hindi nakikita o ano para hindi masayang. Okay. Nasa whiteboard kasi ang problema natin, while it is true that RA 11576 took effect on August 21, 2021, hindi kasama sa coverage. Kaya ganito yung ginawa ko. So we start with jurisdiction. Jurisdiction is the power of the court to try, hear, and decide cases. Jurisdiction is vested by the Constitution and by law. The basic law on jurisdiction is Batas Pambansa bilang 129 as amended by 7691 and further amended by RA number 11576 which took effect on August 21, 2021. Now, dito kasi may pag-iiba ang jurisdiction, baka dito tayo magkaloko-loko. So you have Metropolitan Trial Court, Municipal Trial Court. You have Municipal Trial Court in cities. You have Municipal Circuit Trial Court. So personal action may pinag-iba kasi. Personal action kung Manila ka or Metro Manila ka, 400,000 pababa. Kung ikaw ay probinsya, 300,000 pababa. Real action, 50,000 pababa kung Metro Manila ka. Then 20,000 kung nasa probinsya ka. Kaya magkakaroon ng pagkakaiba yung amount. So this is provided by 7691. Now, nagpasiguro ko under RA 11576 kasi pag naging abogado na kayo by next year, ito na yung susundin ninyo. At 2 million pagka personal action, pababa. Then 400,000 sa real action naman, pababa. Wala nang classification once you become lawyers by next year. Okay? Assuming na ilalabas nila agad yung result ng bar examination. Okay? So ito ngayon ang kailangan alam natin. Ang laging tinatanong, saan natin kukunin? Ano ba tong amount na to sa real action? So these are the assessed value. Pwede mong makuha yan. Take note. Pwedeng makuha sa city municipal assessor. Okay? Pag wala, PIR. Okay? Wala pa rin. Documents executed by the parties. Wala pa rin. Value of the property of adjoining owners. Absent any allegation of the source of the amount is stated in the complaint is a ground for motion to dismiss. Now, Rule 16 has been deleted and or transposed. However, under Rule 15, Section 12, Paragraph A, 1 to 3, you can still file a motion to dismiss on the ground of lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. All other grounds for motion to dismiss not specifically mentioned under Section 12, letter A, 1 to 3, Rule 15 shall be alleged as affirmative defenses. Okay? Now, RTC, mayroon na namang pinag-iba. 400,000 plus 1 or more than 400,000 sa personal action. Take note, exclusive of interest and damages. So pag tiningnan nyo yung problem, ang titingnan nyo lang amount of the principal. Okay? So more than 400,000 pagka Metro Manila. Now real action more than 50,000 Metro Manila. Probinsya more than 300,000. Kaya nilagay ko 300,000 plus 1. Okay? More than 20,000 kapag ka RTC probinsya. Okay? So wag kayong malito dyan. Now, kung ang itatanong ay base na sa 11576, kasi mayroon yatang naligaw na tanong sa criminal law na hindi kasama sa coverage. 2 million or more than 2 million RTC, wala ng classification. Okay? Then more than 400,000, wala na rin classification. Just in case na dito magtatanong sa 11576. Okay? Then you have the Court of Appeals, you have the Supreme Court. Now, Sandigan Bayan, Court of Tax Appeals. So Sandigan Bayan mayroong 7 divisions. Okay? So yung jurisdiction niya, those government employee or officers or employees with salary grade of 27 and above, and the crime was committed in relation to performance of their official duties, then you file it with the Sandigan Bayan. Mamaya i-discuss ko. Ito yung Moya 3 sa civil. Mamaya, mas komplikado, mayroon tayong criminal. I'm pretty sure mayroong itatanong. Okay. Court of Tax Appeals, 3 division lang. Ano ang titingnan mo lang sa problem? 1 million and above. Okay? Then you have the bank. Then Supreme Court, mayroon tayong 3 division. Okay? Mayroon din tayong bank. Now, there are 3 constitutional commission, di ba? CSC, COMELEC, COA. Now, bakit naiiba ang CSC? Okay, nandito siya sa Rule 43. Yung COA saka yung COMELEC covered ng 64 in relation to 65. COMELEC has 2 divisions, mayroong bank. Okay, Vox Populi, Vox Dei. The voice of the people is the voice of God. And therefore, the decision of the Commission on Election in bank is immediately executory. Now, pagdating mo naman sa COA, 2 commissioner, isang chairperson. Wala siyang bank. Now, bakit 64 and 65 ito? Now, COA is the guardian of the purse of the people. Okay, pera natin ang binabantayan niya. And therefore, the decision of the COA is also immediately executory. Okay? Now, dito, kinumbine ko na yung jurisdiction saka yung modes of appeal. Kasi mayroong appellate practice na nakalagay sa coverage. So, ang nakakasakop na rule sa appeal ng MTCs in general, Rule 40. Ang nakakasakop naman sa RTC ay yung Rule 41 if the RTC is the exercise of its original jurisdiction. Now, maraming nalilito. Pag sinabi mong original Diyan mo mismo ipinail yung kaso. Now, RTC is not only a trial court, but it is also an appellate court. Okay? So therefore, from MTC, you appealed it to the RTC, you utilize Rule 42. Now, civil service and all quasi-judicial bodies, with exceptions, pinaka-late na exception, yung SIAC. Okay? Construction Industry Arbitration Commission. Wala na sa Rule 43 yon. Baka itanong, okay? Ano gagamitin mo doon? 65 na, saka 45. Now, tandaan na natin maigi. Pagka papunta ka ng Supreme Court as a rule, makakarating ka lang via Rule 45. Okay? Now, dito naman, kaya nilagay ko yung sa Court of Appeals, nandito yan, 44. Yung proseso doon sa Court of Appeals. Okay? CTA, Court of Appeals, Sandigang Bayan are now co-equal courts. Okay? They are also trial courts and at the same time, appellate court din sila. Okay? So maliwanag na yung ano natin, detalye natin. So pasensya na kayo kung bibilisan ko para marami tayong makover. Now, dito muna tayo sa Sandigang Bayan. Okay? Kasi medyo maintriga rito. Dito sa Court of Appeals, hindi gaano. Except for the case na nangyari during the time of Congressman Pariñas. Okay? Remember yung kaso ng Agkawili et al. Versus Pariñas et al. Yun ang medyo controversial. Now, Dilima versus Guerrero. Okay? Sa Sandigang Bayan. Ano ba nangyari doon sa kaso ng Dilima? So Dilima was formerly a Secretary of the Department of Justice, later elected as Senator in 2016. Okay, a case for violation of 9165 was filed by the PNP through the CIDG with the Office of the Secretary of Justice during that time, Secretary Guevara. Sabi ni Dilima, the crime allegedly committed when I was the Secretary of the Department of Justice, my salary grade is 31. And therefore, sabi niya, wala kayong karapatang mag-conduct ng PI. Dapat i-file yon sa Office of the Ombudsman. Okay? But it was denied by the panel of investigator and after findings of probable cause, it was filed with the Office of the Clerk of Court of Muntinlupa City. Okay? At the same time, Dilima filed a motion to quash the information. The question raised was that if the judge encountered an information and at the same time a motion to quash, uunahin ba niya yung motion to quash? Sabi ng Supreme Court, the primary duty of the court is to determine, judicially determine probable cause for the issuance of the warrant of arrest. Okay? So take note of Dilima versus Guerrero. The rest is history. Now, mayroong nag-iba pagdating ng Ampungan versus Sandigang Bayan. Dilima is from Iriga City. Ampungan was the former vice mayor of Iriga City and I am also from Iriga City, Camarines Sur. Now, Ampungan was the vice mayor, nagkaroon ngayon ng vacancy sa posisyon ng secretary ng Sangguniang Panglungsod. Now, since he was not a party mate of the mayor, nagsumulat siya sa director ng HR, hindi siya inintindi. On his own, nag-recruit si Ampungan. Then after following all the details, all the requirements, na-appoint yung secretary ng Sanggunian. A case for falsification of public document 3019E was filed against Ampungan with the Office of the Ombudsman. Okay? So, the information was filed with the Sandigang Bayan. Sabi ng Ampungan, Vice Mayor lang ako. 26 lang ang salary grade ko, wala kayong jurisdiction. It was denied by the Sandigang Bayan, affirmed by the Supreme Court. Sa dininay, sabi ng Supreme Court, under PD 1606, the original charter of the Sandigang Bayan as amended, if it is for violation of 3019, Anti-Graft and Corrupt Practices Act, pwede na i-file dito sa Sandigang Bayan. The rest is history because Ampungan was later on acquitted. Okay? So ito yan, yung dalawang kasong yan. Now, ang isa sa maintriga rin class ay yung kaso ng Laya Jr. versus Philippine Veterans Bank. as a rule, there is no motion for reconsideration. Second motion is a prohibited pleading in the Supreme Court. So pag natalo ka sa first, second, and third, wala na, tapos na. Now, what happened to Laya Jr.? Laya Jr. Was the head of the legal department of the Philippine Veterans Bank. So PBB offered an ERP, early retirement program. Now, at that time, Laya Jr. was of my age, I think 57 or 58. He did not avail. So, dinismiss siya ngayon ng Philippine Veterans Bank. Nag-file sa labor arbiter, talo. Nag-appeal sa NLRC, talo uli. Then, on Rule 65 sa Court of Appeals, affirm. Then, inakyat niya ngayon sa Supreme Court. Raffle to First Division of affirm ang decision. Last ditch effort, Attorney Laya Jr. filed a second MR and it was taken by the bank. Now, ano sabi ngayon ng Supreme Court? ERP or Early Retirement Program is only voluntary and not compulsory. And therefore, the dismissal was illegal. So the rest is history. I have a chance to meet Attorney Laya Jr. Nagkausap kami what happened and he is happily a retired employee of Philippine Veterans Bank. Okay, ito na ngayon tayo para sapul natin yung appeal. Okay? Now, METC kasama dito yung RSP, Rules of Summary Procedure. Okay, kasama rin yung small claim. Therefore, kung nandito ang kaso, MR is a prohibited pleading. Now, kung hindi kasama sa Rules of Summary Procedure or small claims, MR, motion for recon, is not a prohibited pleading. Okay. So, ipinail mo ngayon dito, MTC, assuming ito yon, nandito yung jurisdiction. MR mo denied with the exception of the RSP and the small claims. Now, further, Rule 70 is included. Di ba? Ejectment suit. There are two kinds of ejectment suit. You have the unlawful detainer and you have the forcible entry. Pagka forcible entry, from the start, the occupation or possession of the property is already illegal. Okay? Now, sa unlawful detainer, it becomes illegal on that expiration of the contract of lease and non-payment of rentals. Now, kailangan ma-file mo within the 1-year period. After the lapse of the 1-year period, it is now the RTC o has jurisdiction. Okay? So take note of that. At titingnan yung problem kung lumagpas na sa 1 taon yung pamomosisyon sa property. After the lapse of the 1-year period, the action becomes plenary and therefore the jurisdiction belongs to the RTC. Now, there is only one exception. If the case is covered by the RSP or small claims, you can file a motion to dismiss on the ground of lack of jurisdiction. Okay. MR talo. Natalo ka, na-deny. Pupunta ka ngayon sa RTC. How do you appeal? Okay? So merely by filing a notice of appeal within the 15-day period and payment of docket fee. Now, huwag niyong kakalimutan yung payment of docket fee pursuant to the landmark decision in the case of Sun Insurance Company Ltd. versus Judge Maximiano Asuncion. It's an old case, but it is still a good case. Now, itong tatlo kailangan ma-comply. Now, in case of ejectment suit, ito, and there is a word of back rentals. Okay? Mayroong pang-apat na requirements, posting of supersedious bond. Now, marami nagtanong, sa pag-post pa ng supersedious bond, kasama ang damages and attorney's fees? Answer, no. Kasi hindi pa naman final yon. Okay? Kung umapila ka. So take note pagka tinignan nyo yung problem. Okay. RTC. So, umapila ka from MTC to RTC, ginamit mo Rule 40. Okay. Now, RTC final, original, Rule 41. Natalo ka, MR denied, akyat ka ngayon sa Court of Appeals. Okay, how do you appeal? Notice of appeal plus payment of docket fee within 15 days. 2019 bar examination. Can you file a motion for extension of time to file notice of appeal? Answer, no. Now remember, Rule 39, Section 1, decision becomes final and executory after the lapse of the 15-day period without the adverse party filing a motion for recon or appeal. So it becomes final and executory pag hindi ka nag-file ng MR or appeal within the 15-day period. Therefore, there is no motion for extension of time. Okay. Sabi ko kanina, ang RTC is not only a trial court, it is also an appellate court. So di ba galing MTC, inapila mo, nag-notice of appeal ka. If the RTC affirmed the decision, akyat ka ngayon sa Court of Appeals. How do you appeal? Yun ang tanong. Okay? You go to the Court of Appeals by filing petition for review. How many days you have? 15. Is it extendable? Yes. Plus 15 equals 30. What should you do to get the 30-day period? Okay? Motion for extension plus payment of docket fee. When do you file the motion for extension? It must be filed within the 15-day period. Okay? 40, 42, tapos tayo. Now, there is only one way in going to the Supreme Court. So, pag ang kaso nasa Court of Appeals, regardless whether the RTC is in the exercise of its original jurisdiction or appellate jurisdiction, in going to the Supreme Court, you utilize Rule 45. Okay? Now, tingnan ninyo yung Rule 45 as distinguished from Rule 65, yung caudal provision ninyo. Okay? It is an appeal. So, what is the proper term if you utilize 45? Appeal by petition for review on certiorari. Petition for certiorari is an original action under Rule 65. Tingnan nyo yung caudal ninyo. Okay? Now, since it is an original action, i-summarize ko na uli, RTC, Court of Appeal, Supreme Court has concurrent jurisdiction over petition for certiorari, provision, mandamus, quo warranto, habeas corpus, and the 3 special rules. Writ of amparo, writ of kalikasan, and writ of habeas data. Okay? Pasok. Now, CA to the Supreme Court, Rule 45. How many days do you have? You have 15. Is it extendable? Yes. Plus 30 equals 45. Rule 45. Sinagkalimutan yan. Kasi ang maximum mo 45. Question, paano mo gagawin? Motion for extension plus payment of docket fee. You can get the maximum 45 days under Rule 45. Now, you raise only purely question of law. Exception to the rule. You can raise mixed question of facts in law in the 3 special rules. Ano yun? Writ of amparo, writ of kalikasan, and writ of habeas data. Okay? So, iyon ang hierarchy papunta Supreme Court. Okay? Now, punta muna tayo dito naman, Sandigang Bayan. Okay? So, if the case is originally filed with the Sandigang Bayan, meaning at 27 and above yung salary grade niyan, can private individual and those with lower salary grade of 27 be included? The answer is yes, provided there is an allegation of conspiracy. Okay? Now, from the Sandigang Bayan originally filed, in going to the Supreme Court, you merely file notice of appeal within 15 days. Okay? So, tatandaan na ninyo, ano titingnan mo? Originally filed. If not originally filed, ibig sabihin, below 27, may jurisdiction din kasi yung RTC pwedeng i-file dito. So, dinala mo ngayon dito. Nag-notice of appeal ka, inakyat sa Sandigang Bayan. In going to the Supreme Court, if the decision is affirmed, how do you appeal? Rule 45 ka na. Okay? Magno-notice of appeal ka lang kung originally filed doon sa Sandigang Bayan. Pagka hindi originally filed, the Sandigang Bayan is in the exercise of its appellate jurisdiction from the Sandigang Bayan after if the decision is affirmed from the RTC, MR denied, in going to the Supreme Court, Rule 45 ka. Okay? Now, punta tayo ngayon dito sa Court of Tax Appeals. There are 3 divisions. Natalo ka, first, second, third. It presupposes na ang pinag-uusapan natin dito ay 1 million and above. Okay, below 1 million, RTC ka. So the same process. From RTC in going to the Court of Tax Appeals, notice of appeal ka. Affirm ng Court of Tax Appeals in going to the Supreme Court, Rule 45 ka. Purely question of law. Now, natalo ka first, second, third. Okay? How do you appeal? Can you go to the Supreme Court directly? No. You go to the bank. What did you do? Petition for review. How many days? 15. So, extendable ba? No. Kasi instead na motion for recall, ang rules nila sinasabi petition for review. Okay, from the bank, going to the Supreme Court, Rule 45 ka. Okay? Purely question of law. So, covered na natin. Punta tayo ngayon. Madalian tayo ngayon dahil ano na lang to. Actually, wala nang pre-week. Anong panahon namin? 1 week talaga. Okay, Rule 43 and quasi-judicial bodies. So, siyak, minus na to. Wala na yan diyang siyak. Now, ininagay yung civil service because the Civil Service Commission is the biggest employment agency in the Philippines of the government. Okay? So, those who have less in life must have more in law. Under the doctrine of double appellate review, pagkagaling ng 43, it presupposes that MR is denied. Denied ng civil service, going to the Court of Appeals ka. Okay? What should you do? Petition for review. How many days do you have? 15. Okay? Is it extendable? Yes. Plus 15 equals 30. What should you do? Motion for extension plus payment of docket fee to get the maximum of 30 days. Okay. Affirm ng ng Court of Appeals. Umapila ka, affirm. Going to the Supreme Court ulit of Rule 45 ka. Okay? Follow the process. Okay? Now, tapos na natin. Punta tayo dun sa dalawang malalaking constitutional commission din. COMELEC muna. Baka magtatanong sa COMELEC ngayon. Natatapos lang ng eleksyon. Okay? Natalo ka first or second division. Can you go to the Supreme Court directly? Answer no. What is the reference that you cannot go to the Supreme Court from first or second division? You have the case of Villarosa versus Commission on Election and Romulo de Mesa Pistin. It is the contest of the municipal mayor in San Jose, Occidental Mindoro. So, from first or second division, natalo ka, you go to the bank. Okay? What should you do? You file motion for recon within 15 days. Is it extendable? No. Okay. Pagka natalo ka sa bank, that's the proper way in going to the Supreme Court. Okay? Rule 64 in relation to Rule 65. Pag tinignan nyo, lahat ng kaso sa Rule 64, lahat yan in bank. Pag dinala sa Supreme Court. Ano ground mo? God. Okay? Grave abuse of discretion. How many days do you have? Ito ang pinag-iba ngayon. While it is true that 64 in relation to 65, ang 65, meron kang 60 days. But if you utilize 64 in relation to 65, meron ka lang 30. Bakit 30 lang? Can it be extended? No. 30 days is provided for by the Constitution. And therefore, it cannot be amended by the rules of court. The Constitution is the fundamental law of the land. It is the basic law. So meron kang 30 days. Now, sabi natin kanina, immediately executory. Therefore, if you go to the Supreme Court, you need to apply for a TRO, injunction, or SQA. Status quo ante order. Absent the issuance of TRO, injunction, or SQA, decision of the COMELEC will now be executed. Okay? Clear. Now, punta tayo ngayon sa COA. At dalawang commissioner, isang chairperson. After the denial of your MR, kung yan ay na-deny, You can go to the Supreme Court. Okay? How many days? 30 din. Ano ground mo? Gun. Oh. Mga dalawa. Pwede dalawang tanong dito. Makalima lang ako, maligaya na ako. Bahala na kayo doon sa 10. Kung tamaan natin pare-pareho, di mas maganda. So, ito na yung appeal process and jurisdiction sa civil procedure. Kasi pinag-classify kasi ng Supreme Court yung mga topic. Ito usually mahirap intindihin. That is why nag-formulate ako in a way na madali nating intindihin. Ang problema lang, kailangan marinig mo ko. It's all over in my Facebook. Ang problema lang, napakaraming araw. So dapat pakinggan mo. So, nakatipid ka na ng ilang rules. 40, 41, 42, 43, 44, 45. So ilan na yan? Then 64, 65. Now, ang isa pa, maraming controversy ngayon. Mayroon tayong controversy kay Bantag. Mayroon tayong controversy ngayon doon kay Bong Navarro. So therefore, yung jurisdiction and appeal process doon, pwede rin lumabas ngayon. Okay, give me 5 minutes, ibuburahin ko na to. Then yung criminal naman. Kasi sigurado rin ako meron lalabas doon. Noemi, mag-ano muna ako. Ipapabura ko lang. Pakibura na. Ami! Adi man na ami. Nagli-lecture ako. Agko kausip man sa. Gusto mo na mag-lecture. Nariringagi ka. Bulay kitang mga tao. Buburay mo na to. Dali, ito yung eraser.
Ako si Romel, Proud Print Production Manager.
Ako si Giselle, proud pre-press artist.
Ako si Dom, proud ako na production supervisor.
Ako si Ann, proud editor.
Ako si Jonah, proud researcher.
Ako si Chris, proud author.
Ako si Roxanne, proud artist.
Ako si Nelly, proud sales assistant.
Proud ako na nagagamit ko ang aking talento para matulungan ang isang estudyante, guro o magulang na magkaroon ng imahen ng isang aralin na kanilang gusto o kailangan matutunan.
Proud ako kasi sa umpisa pa lang ng book development, kasama na ako. Working with the authors, so sa journey ng libro hanggang sa magamit na ito ng mga learners. Para makatulong to make them whole and responsible Filipinos. It's a good feeling.
Maaring sa iba ay tagasakay ka lang naman ng papel sa makina. Ngunit, ang kada papel na yon ay siyang bumubuo ng isang libro na nakatutulong sa isang bata o sa isang tao upang matuto at umunlad. Proud ako na maging bahagi ng prosesong ito.
Proud ako na yung pinag-aralan ko, yung pinagsikapan ko, yung pinuhunan ko ng bawat oras, pagod at puyat, ngayon buo na, ngayon isa ng libro. I am full of hope na ang bawat makabasa nito, matuto, makinabang at makibahagi.
Teacher ang nanay ko. Proud akong gumising sa bawat araw na alam kong may ginagawa ko na makakatulong sa kanya sa araw-araw niyang pagtatrabaho.
Proud ako maging print production group manager dito sa Rex Printing dahil ang ginagawa naming libro ay nagbibigay ng kaalaman sa mga kabataan. At isa pa, siyempre nagbibigay financial support sa aking pamilya. Kaya proud ako.
Yung anak ko, nakita ko na hawak niya yung isang libro na inimprenta natin. Nakwento daw niya sa mga kaklase niya na dito ako nagtatrabaho sa Rex. Nabanggit din niya yung mga pagbabasa at pag-e-edit na ginagawa ko sa mga produkto natin para masiguradong maganda at maayos ang kalalabasan ng mga produkto. Gabi na nga daw ako umuwi kung minsan para lang matapos yung libro. Para sa pamilya, para sa bata, konting sakripisyo, kayang-kaya.
Nung nag-aaral ako, marami rin kaming libro. Lalo na yung nag-aaral ako sa law, Never akong gumamit ng photocopy or illegal downloads. Gusto ko kasi yung pakiramdam na may hinahawakan ka ng totoong libro. And those books helped me become who I am today. So proud ako kasi alam kong may isang tao rin ako matulungan sa pagsusulat nito.
Proud ako kasi bawat customer na nakakaharap po namin dito sa branch, laging may kwento. Ang anak ko, naku, ayun, pumasa na sa kanyang exam. Salamat sa inyong libro. O di kaya may lalapit na, buti na lang may kopya kami ng ganitong title. Hulog kami ng langit. Ang makita ng ganitong mga ngiti sa mga customers sa tuwing nakakuha sila ng kopya ng title ng libro, nakakagaan din ng loob. Kasi parang naging parte na rin tayo ng buhay nila at ng journey nila.
Ako si Tony Morano, proud customer of Rex. Sa lahat ng nagbigay ng oras, atensyon, expertise, sa lahat na rin na nagpagod at nagpuyat para sa mga libro ngayon ay lifeline ko. Proud book owner ako at proud ako sa inyo.
It takes a whole community to raise a whole child, and a whole community to create learning solutions to help every learner. Sa lahat ng edukampiyon sa likod ng bawat papel ng ating mga libro, proud kami sa inyo.
Okay, we are back. I hope everybody was able to take advantage of the break. We would like to check in if Dean Moya II is available, or if Dean, are you ready na po to continue your lecture? Okay, so while we're waiting for Dean, we would like to remind everybody that we were Dean. Okay, hala ko Dean's back. But we would like to remind everybody that we are still having we're still having 2 more lectures after this. That's going to be tomorrow and on Saturday. So make sure to follow the PALS and Rex Books or Facebook pages so that you guys can be aware of the schedules for the remaining lectures we have for you. Okay, just checking in with Dean Moya II if he's ready to resume his lecture. Yeah. Okay, as you wait for Dean, I would also like to ask if you guys have any questions, please leave them in the comments and Dean can get to them after his lecture. So, yeah. We have another AVP from Rex, so please watch them.
Okay, I'm back. Maliwanag ba? Noemi? Nakikita ba sa screen?
Yes po, Dean.
Okay. So, dito tayo sa kanina civil procedure. Okay, ngayon naman ay criminal. Medyo ang suspecha ko may mga itatanong dito ngayon. Kasi maraming controversial cases. So, dito muna tayo sa unang layer, tapos pangalawang layer. Okay? Now, pagdating ng October 3, 2005, na-amend yung Section 2 ng 112. Kung titingnan ninyo, nawala na dyan yung MTC, Judge to Conduct, PI. Now, ang problema, pagdating mo doon sa Section 1B, o second paragraph ng 110, ang nakalagay kasi, you can file it directly with the MTC outside Metro Manila. Okay? Wala na yon. In case of conflict between two provisos of law or rule under the rule of statutory construction, the later one prevails. So, pagdating ng October 3, lahat ng kaso ay dadaan na sa piskal o ombudsman. Wala nang direct filing. So ACP, Assistant City Prosecutor, APP, Assistant Provincial. So you have the OCP, Office of the City Prosecutor, Office of the Provincial Prosecutor. Pagtaas mo, Prosecutor General sa Metro Manila lang yan. Outside Metro Manila, RSP, Regional State Prosecutor. Taas ka uli, Secretary of Justice. Taas uli, OP, Office of the President. Now, dito naman, Graft Investigator, Overall Deputy Ombudsman for Luzon, Visayas, Mindanao, Moleo, or Deputy Ombudsman for the Military and other uniformed personnel, then Ombudsman. Okay? Then you have the Sandigan Bayan, pareho, 27 and above, you have the Court of Appeals, you have the Court of Tax Appeals, pareho pa rin yan, yung jurisdiction yan, 1 million pataas. Then you have the Supreme Court, first, second, third, then you have the bank. Okay. Dito, wala tayong problema. MTC sa probinsya, MTC Metro Manila, RTC sa Metro Manila, RTC sa probinsya. Ano lang titingnan mo? The imposable penalty. So dito, 6 plus 1 or more than 6 years. MTC, 6 years, bababa, including those cases covered by the RSP. So, ang sabi natin, wala nang direct filing sa probinsya. Now, covered pa rin yung appeals process. Bakit? May DOJ Circular 70 saka 70-A, may DOJ Circular 018-14. Okay? Now, lahat ng criminal cases as a rule dadaan sa piskal. Okay? Pag sa probinsya ka, provincial prosecutor. Pagka city, mayroong city prosecutor dyan. Now, after raffle, ibababa dito sa ACP, saka sa APP kung probinsya. Question, is the finding of probable cause is appealable? Is it appealable? Answer yes. So you can go to the OCP or OPP, you can file an MR. How many days do you have? 15 days. Okay. If the findings of probable cause is affirmed by the OCP or OPP, papasok yung 018-14. If the jurisdiction or if the crime committed is punishable 6 years and below, ibig sabihin MTC yung jurisdiction. From OCP or OPP, hindi ka pwede nang dumirekta sa SOJ. Pag nasa Metro Manila ka, aakyat ka sa PG. Pagka sa probinsya ka, aakyat ka sa RSP, Regional State Prosecutor. Example, Tarlac, Region 3 yun. Now, what should you do? Petition for review. How many days do you have? 15. Now, as a rule, final. Pag in-affirm ng PG or RSP. But it does not preclude the Secretary of Justice to review the findings of the PG or the RSP. Okay. If the crime committed is within the jurisdiction of the RTC naman, MR mo, galing ACP, APP, denied. Where do you go? So pupunta ka ngayon sa SOJ. Ang mag-govern, DOJ Circular 70 as amended by 70-A. Pagka MTC, ang mag-govern, DOJ Circular 018-14. Okay, ano gagawin mo from OCP to OPP? Petition for review. How many days do you have? 15. Okay, now, if the crime committed is punishable less than reclusion perpetua or life imprisonment, final. There is no appeal. Okay? So, remember, the 14 ill elements of Rule 65. If there is, magbilang kayo, 14. If there is no appeal, plain, speedy, adequate remedy in the ordinary course of law, 7. There is grave abuse of discretion amounting to lack or excess of jurisdiction, another 7. 14. From SOJ, gusto mong questionin saan ka pupunta. Pupunta ka ngayon sa Court of Appeals. Anong rule? 65. How many days do you have? 60. Is it extendable? If there are compelling reasons, plus 15 equals 75. Yan yung maximum. Okay? So, if you file a motion for extension, ano gagawin mo? Motion for extension plus payment of docket fee within the 60-day period. Now, if the crime committed is punishable by reclusion perpetua or life imprisonment, may isa pang ladder na pwedeng akyatan. You can still go to the OP, Office of the President. What should you do? Memorandum of Appeal. How many days do you have? 15. Now, if it is affirmed by the OP, the findings of the Office of the President is appealable. If the Office of the President review the findings of the Secretary of Justice, he is exercising quasi-judicial power. Okay? If the Secretary of Justice review the findings of the OCP, OPP, PG, or RSP, the Secretary of Justice is merely exercising supervisory power. So, quasi-judicial, anong rule ang gagamitin mo? Appealable. Rule 43. Okay, punta ka sa Court of Appeals. Ano gagawin mo? Petition for review within 15 days. Extendable? Yes. Plus 15. What should you do? Motion for extension plus payment of docket fee within the 15-day period. Okay? From Court of Appeals in going to the Supreme Court, isa lang yan. Ano sabi ko? Rule 45. Kasi appeal process yun. So ito yung hierarchy ng piskal. Now, punta tayo dito ngayon sa kabila. Ombudsman. So, 27 and above. The crime was committed in relation to the performance of his official duties. Now, ano ngayon paano ngayon kung mayroong private individual or lower salary grade? Anong kailangan? There must be conspiracy. Okay? Allegation that there is conspiracy. The akab-1 is the akab-all. Okay. From ombudsman, kung ikaw ay nasa Luzon, andyan sa Quezon City, Bisaya, asa Cebu, Mindanao, asa Cagayan de Oro. So, ibababa ngayon sa graft investigator. Ayun yun. Kaya magkapantay sila. Now, mag-iiba ngayon dito. If in your complaint, joint yung criminal and administrative, magkakaroon ng twin resolution. Okay? Now, is the finding of the graft investigator appealable? Answer yes. Okay? You can go to the ombudsman. Kapag ka criminal, you can file an MR within 5 days only. Pagka administrative, you can file your MR within 10 days. Okay? Now, if it is affirmed by the ombudsman, assuming in-affirm yung criminal, dito tayo. If affirmed by the ombudsman, that is final. There is no appeal. Okay? Where do you go? You can go to the Supreme Court. Anong rule? Rule 65. Ano ground? God. Grave abuse of discretion. Now, pagdating mo ngayon sa administrative, assuming it was denied, mayroong classification ngayon. If the penalty imposed is 30 days suspension or forfeiture of salary, reprimand, or admonition, it is final and executory. There is no appeal sa admin. So where do you go? You go to the Court of Appeals. Anong rule ang gagamitin mo? Rule 65 kasi wala nang appeal. So, if it is more than 30 days suspension or forfeiture of salary, admonition or reprimand, pagka sumobra dyan, the findings of the ombudsman is appealable. Okay? Where do you go? You go to Court of Appeals. Ano gagawin mo? Rule 43. So maximum yan 30. Pinaliwanag ko na kanina. So take note, ito yung appeal process naman at kung paano mag-file, ano gagawin mo, saan ka apila o kaya walang apila. Tandaanan yung admin, yung imposed penalty. Okay? Pag nandito yung imposed penalty, final. Okay? Rule 65, Court of Appeals. Kapag ka more than appealable. Okay? Anong gagawin mo? Rule 43. So, fiscal, ombudsman. Okay. So, sabi ko, ang appeal class sa criminal cases almost the same with the civil cases. Walang pinag-iba yun. Ang exception lang ay Section 3, Rule 122 in relation to Section 3C, Rule 124. Ito, C rin. Ano itong dalawang ito? If the crime committed is punishable by reclusion perpetua or life imprisonment. Okay. Simula tayo sa baba. Now, sabi natin, effective October 3, tingnan ninyo yung caudal ninyo. Wala nang nakalagay dyan na MTC. Okay? So, nagkaroon ngayon dyan ng kaso. Yung kaso ng Conquilla versus Bernardo. Judge Bernardo was the MTC judge of Bukawi, Bulacan. Tumanggap siya ng kaso, direct filing, nag-issue ng warrant, dinimanda siya. And he was cited by the Supreme Court for gross ignorance of the law. Because 2011 na yon. At 2005 pa lang, wala nang karapatan. Okay. Dito, includes also cases, criminal case covered by the RSP, city, municipal ordinance, lahat yan dito sa MTC. Ang titingnan mo lang ay yung imposable penalty, 6 years pababa. Okay? Convicted. Assuming na hindi covered ng RSP, nag-MR ka denied. How do you appeal? Akyat ka ngayon ng RTC, papile ka lang notice of appeal plus payment of docket fee within 15 days. No motion for extension. Tandaan na natin. Pagka originally filed. Okay? Notice of appeal ang gagamitin ninyo. Okay. Pagka ang imposable penalty ay more than 6 years, RTC mo ipinail, MR, convicted, MR, denied, in going to the Court of Appeals, then what should you do? Notice of appeal plus payment of docket fee. Okay? How many days? 15. Anong rule ginamit mo? 41. Dito ginamit natin 40. Okay, ang sabi ko, pagka galing MTC, inapila mo sa RTC, affirm ang conviction mo, akyat ka ulit sa Court of Appeals of Rule 42 na yan. Because the RTC is now in the exercise of its appellate jurisdiction. So what should you do? In going to the Court of Appeals, petition for review within 15 days. Okay? Plus payment of docket fee. Now, extendable ba? Yes, you can file a motion for extension. Now, the question is, does the NAPIS rule applies in criminal cases? Yung NAPIS kasi may tinatawag na press period rule. After the denial of your MR, binibigyan ka pa ng 15 araw. Now, it was answered also in the case of you versus Tatad. Sabi ng Supreme Court, walang pinag-iba. Ang civil sa criminal. So therefore, the press period rule applies. Na-convict si you sa Quezon City ni Judge Tatad. Nag-file siya ng MR, denied. Okay? After the denial of the MR, nag-file siya ng notice of appeal, deny pa rin. Sabi, final na. Inakyat niya sa Supreme Court. Entitled ba ako sa press period rule? Like in NAPIS, the Supreme Court answered positively. Na-entitled ka. Now, ang sabi ko kanina, mag-iiba pagdating dito because of the penalty. Okay. From RTC, inakyat mo sa Court of Appeals, kaso mo rape, murder. Okay? Ano imposable penalty? Reclusion perpetua. Under the doctrine of double appellate review from the Court of Appeals, if the penalty imposes reclusion perpetua or life imprisonment, in going to the Supreme Court, you merely file a notice of appeal within 15 days. So titingnan ninyo yung problem. Ano ba ang sentensya? Affirm ba? Kung affirm ng Court of Appeals, notice of appeal. Question, is a one sentence answer? Can you answer in one sentence din? Yes. Pwede. The examiner will be very happy for you. There are more than 9,000 who took the bar examination. Pag hinabaan nyo ng gusto, magagalit yung examiner. Kahit ma-computerize yan, binabasa pa rin yan. Now, Court of Appeals, okay, below reclusion perpetua, okay, or life imprisonment. Convicted ng RTC, inapila mo, notice of appeal ka, inakyat sa Court of Appeals. Okay, now, in going to the Supreme Court, Rule 45 ka lang. Okay, purely question of law. Ulit, 15 days, extendable to 30, equals 45, Rule 45. What should you do? Motion for extension plus payment of docket fee. So, nagmamatter ngayon yung penalty imposed. Remember, there is no more automatic appeal dahil wala nang death penalty. So, kinakailangan kung ma-affirm yung sentensya mo, mag-file ka ng appeal. Ang tatandaanan mo lang, ano ang inimpose na penalty. Okay? Pagdating mo ngayon sa Supreme Court, tandaanan mo lang, purely question of law, below reclusion perpetua or life imprisonment. Now, if it is reclusion perpetua or life imprisonment, notice of appeal lang tayo. Now, yung dito sa Sandigan Bayan, nasabi na natin kanina, originally filed, akyat, notice of appeal. Okay? If not originally filed, Sandigan Bayan in the exercise of its appellate jurisdiction, galing RTC, inakyat sa Sandigan Bayan, ibig sabihin below 27, ang salary grade. Papunta doon sa Supreme Court Rule 45. Now, the same thing class, yung doon naman sa CTA, first, second, third. Okay? 1 million. So, talo, kung natalo, akyat ka muna, petition for review. Okay? So, talo uli, akyat ka ngayon Supreme Court. Rule 45 lang yan. Purely question of law. So, clear tayo sa criminal. Mayroon bang tanong? Kaya lang, napakarami nyo yata. Hindi ko kayang sagutin lahat yan sa isang anuhan lang. I have given a limited time. So, clear ba tayo? Tingnan nyo muna maigi. Kung mayroon kayong hindi ma-decipher. Ombudsman, tandaanan ninyo, pag nag-MR ka, 5 araw lang yan. Sa criminal. Kapag ka-admin, mayroon kang 10 araw. From receipt of the decision or resolution. So from ombudsman, tatandaanan mo rin. Pagka criminal, Supreme Court lang, hindi Court of Appeals yun. Okay? Kapag ka-administrative, tingnan mo yung problem, ano ba yung inimpose na penalty? So, pagka higher than 30 days, suspension or forfeiture of salary, reprimand, admonition, then, pag nakita mo na ganun lang yung penalty, final. No appeal. Ano gagawin mo? Gusto mong questionin? Rule 65 ka. Court of Appeals lamang yon. Now, pagka more than, then Rule 43 appealable. To dito, baka lumabas yung kaso ni Bong Navarro. Medyo mainit yun. Naglaylo lang kasi napalitan nung kaso ni Bantag. But I believe, malamang itanong yon kasi nasa isip na ng examiner yon as of now. So MTC, RTC, wala namang ibang court na sa Pilipinas. Ito na yon. Yung kanina civil, ito namang criminal. Okay? So tanggalin ko na yung share screen. At least makadalawa tayo rito. Makadalawa tayo doon sa civil. O malaki-laki na laban, dalawa or tatlo. Kasi nakuha na natin yung 40, 41, 42. May 43 tayo, may 64 tayo, may 65 tayo. So malaki-laki na ang laban din dito. 25% yata ang remedial law sa umaga. Okay, so it remains. Yung pa rin ang pinakamataas. So marami kong natanggap na feedback from my former students, reviewees, napakahirap daw nung civil. So at least makabawi man lang tayo sa remedial. Because remedial law is the determining factor whether you will become a lawyer or not. So this is the lone subject na half day kayo at 25%. So it remains. So galingan natin. Kung as much as possible, yung sagot natin ay iklian lang. Kasi napakarami yung kumuha ng exam. Regardless kung 3 o 4 ang examiner dyan, the same number ang chichikin nila. Limited nga lang yung question. Kasi baka pinaghati-hatian. Okay? Sige, pakiano muna.
Thank you, Dean Moya II. We will be having a short break, but before we get to that, we'd like to thank our sponsors, Rex Bookstore and Rex Educampion. Make sure to check them out. If you have any questions for Dean Moya II, please leave them in the comments and we will get to them after his lecture so he can answer your queries. We will now have a short break and we will see you guys in a bit.
Ako si Romel, Proud Print Production Manager.
Ako si Giselle, proud pre-press artist.
Ako si Dom, proud ako na production supervisor.
Ako si Ann, proud editor.
Ako si Jonah, proud researcher.
Ako si Chris, proud author.
Ako si Roxanne, proud artist.
Ako si Nelly, proud sales assistant.
Proud ako na nagagamit ko ang aking talento para matulungan ang isang estudyante, guro o magulang na magkaroon ng imahen ng isang aralin na kanilang gusto o kailangan matutunan.
Proud ako kasi sa umpisa pa lang ng book development, kasama na ako. Working with the authors, so sa journey ng libro hanggang sa magamit na ito ng mga learners. Para makatulong to make them whole and responsible Filipinos. It's a good feeling.
Maaring sa iba ay nagasakay ka lang naman ng papel sa makina. Ngunit, ang kada papel na yon ay siyang bumubuo ng isang libro na nakatutulong sa isang bata o sa isang tao upang matuto at umunlad. Proud ako na maging bahagi ng prosesong ito.
Proud ako na yung pinag-aralan ko, yung pinagsikapan ko, yung pinuhunan ko ng bawat oras, pagod at puyat, ngayon buo na, ngayon isa ng libro. I am full of hope na ang bawat makabasa nito, matuto, makinabang at makibahagi.
Teacher ang nanay ko. Proud akong gumising sa bawat araw na alam kong may ginagawa ko na makakatulong sa kanya sa araw-araw niyang pagtatrabaho.
Proud ako maging print production group manager dito sa Rex Printing dahil ang ginagawa naming libro ay nagbibigay ng kaalaman sa mga kabataan. At isa pa, siyempre nagbibigay financial support sa aking pamilya. Kaya proud ako.
Yung anak ko, nakita ko na hawak niya yung isang libro na inimprenta natin. Nakwento daw niya sa mga kaklase niya na dito ako nagtatrabaho sa Rex. Nabanggit din niya yung mga pagbabasa at pag-e-edit na ginagawa ko sa mga produkto natin para masiguradong maganda at maayos ang kalalabasan ng mga produkto. Gabi na nga daw ako umuwi kung minsan para lang matapos yung libro. Para sa pamilya, para sa bata, konting sakripisyo, kayang-kaya.
Nung nag-aaral ako, marami rin kaming libro. Lalo na yung nag-aaral ako sa law. Never akong gumamit ng photocopy or illegal downloads. Gusto ko kasi yung pakiramdam na may hinahawakan ka ng totoong libro. And those books helped me become who I am today. So proud ako kasi alam kong may isang tao rin ako matulungan sa pagsusulat nito.
Proud ako kasi bawat customer na nakakaharap po namin dito sa branch, laging may kwento. Ang anak ko, naku, ayun, pumasa na sa kanyang exam. Salamat sa inyong libro. O di kaya may lalapit na, buti na lang may kopya kami ng ganitong title. Hulog kami ng langit. Ang makita ng ganitong mga ngiti sa mga customers sa tuwing nakakuha sila ng kopya ng title ng libro, nakakagaan din ng loob. Kasi parang naging parte na rin tayo ng buhay nila at ng journey nila.
Ako si Tony Morano, proud customer of Rex. Sa lahat ng nagbigay ng oras, atensyon, expertise, sa lahat na rin na nagpagod at nagpuyat para sa mga librong ngayon ay lifeline ko. Proud book owner ako at proud ako sa inyo.
It takes a whole community to raise a whole child, and a whole community to create learning solutions to help every learner. Sa lahat ng edukampiyon sa likod ng bawat papel ng ating mga libro, proud kami sa inyo.
Naomi, resume na ako para makarami. Okay, I'm back. Okay, general principles. Baka may itanong. Although walang definition, walang distinction akong nakikita doon sa mga previous examination sa political, labor, walang masyado. So meaning application. So doctrine of stare decisis. Ano ang tatandaanan mo rito? Article 8 of the Civil Code. Decision of the Supreme Court shall form parts interpreting laws, or the Constitution shall form parts of the law of the land. Okay? Moot in academic. So therefore, it no longer presents any justiciable controversy. Now remember, mayroong decision si Justice Kagiwa rito. Dangerous Drugs Board versus Matibag. January 22, 2020. Okay? So, doon sa principles, ang kailangan niyo lang ay may apply doon sa problem na ibibigay sa inyo. So, I will just make a random wise guess. Sana yung mga sasabihin ko ay lumabas like in the previous bar examination. Hindi naman tayo manghuhula, okay? Pero sometimes napo-forecast din natin ano yung possible ba na ilabas. Okay? Now, doctrine of exhaustion of administrative remedies. Okay? Now, recourse through court action as a general rule cannot prosper until all the remedies have been exhausted at the administrative level. Okay? Ito yung kaso ng Colmenares versus Energy Regulatory Commission. In-bank decision. So maikli lang yung mga isasagot natin dito. Okay? Now, rule-making power of the Supreme Court. Ano yung papasok agad sa utak mo? Kasabay nito ay yung doon sa plea bargaining. So Rule 18, pagka civil cases, pre-trial is mandatory. Rule 118, pagka criminal cases, correlated with Rule 116, as amended by the revised guidelines on continuous trial in criminal cases. After the arraignment kasi, pre-trial na agad. Kaya dapat ready ka na sa pre-trial. Now, what happened doon sa Estipona versus Lubrigo? Sa rulemaking power of the Supreme Court, it declared Section 23 of RA 9165 to be unconstitutional. The Supreme Court traced the origin of the rules of criminal procedure way back during the American time. And therefore, it is not subject to legislation. So that is the difference between the US and the Philippines. In the US, the rules of court is a substantive law. In the Philippines, it is a procedural law. Sa US, kinopya natin yung civil procedure, saka yung rules of evidence, which took effect in May 1 of 2020, substantive Congress, recommendatory lang yung Supreme Court. Pero sa Pilipinas, it is the Supreme Court. So dapat papasok sa utak mo agad yung decision doon sa Estepona versus Lubrigo, which is an in-bank decision. Now, hierarchy of courts. Ano dapat ang papasok din sa iyo? The lecture ko na kanina, yung Dilima versus Guerrero. Mayroong violation ng doctrine of hierarchy of courts because na-bypass yung Court of Appeals. Doctrine of non-interference. Can the Supreme Court interfere with the findings of probable cause of the Office of the Ombudsman? Can the Office of the Ombudsman or the findings of the Office of the Ombudsman, even if it is final and executory, mayroon pa ring Rule 65. Ano ground? Grave abuse of discretion. And therefore, the Supreme Court can interfere. Okay. Jurisdiction, na-discuss na natin. Power of the court to try, hear, and decide cases. Jurisdiction is vested by the Constitution and by law. Jurisdiction cannot be vested by the parties. So take note of that. Yung sa jurisdiction original. Okay. Para kabisado agad. RTC, Court of Appeals, Supreme Court. Concurrency of jurisdiction. Petition for certiorari, prohibition, mandamus, quo warranto, habeas corpus, and the 3 special rules. But can you go to the Supreme Court directly? Now, the answer is no because of the doctrine of hierarchy. Now, remember, the Supreme Court said that even the regional trial court has the power to determine or to act on question of law, subject only for review. So yung concurrency, napaka-importante. Tandaanan natin. Yung RTC, Court of Appeals, and the Supreme Court. Okay? Hindi po pwedeng basta ka lulukso. Napaka-harsh nung sinabi ng Supreme Court, parang galit na galit. Dun sa kaso ng Dilima, na marami daw na kaparehong kaso, suffering also. Bakit pupunta agad sa Supreme Court? Now, how about determination? Determination of just compensation para sa mga agrarian. Tiningnan ko yung labor kasi walang lumabas. Baka itanong dito. Now, preliminarily, ang magdidetermine ng just compensation, DAR. If you want to question, you can go to the court, Regional Trial Court designated as SAC, Special Agrarian Court. Okay? So take note of that. Now, tingnan nyo rin maigi yung jurisdiction, nagbabari ang jurisdiction ng MTC saka RTC. And therefore, kung doon tayo sa 7691, uulit-ulitin ko. Although I gave my materials nasa Facebook ko para maraming makapag-download, I did not come up with a new edition of my book. This is public service to the students who are taking the bar examination as my sign of gratitude in adapting my books. So binigay ko na for free. Instead na gawin kong libro, ibinigay ko na lang for free. Okay? So tingnan ninyo kagad principal amount. Maraming nalilito doon. Principal amount lang ang pinag-uusapan natin. Now, doon sa real action, tingnan nyo yung problem. Anong titingnan mo? Assess value. Saan makukuha? City Municipal Assessor. Walang assess value, zonal valuation. Saan makukuha? BIR. Wala pa rin documents executed by the party, deed of absolute sale, deed of absolute assignment, etc. Tingnan mo rin yon. Wala pa rin value of the properties of adjoining owners. Now, absent allegation. Pag walang allegation doon, the court can even motu proprio dismiss the case. The reason why the court is given 5 calendar days sa mga multiple sala courts or even in a single sala court upon receipt of the complaint before issuing the summons. Okay, palukso agad ako doon sa summons. Okay, now natural person 30 calendar days. You can file your answer or responsive pleading. Juridical person 60. Okay, upon receipt of the complaint. Now, is it extendable? Yes, only for once. Another 30 calendar days. Huwag niyong kakalimutan yung calendar. Now, jurisdiction over the person of the plaintiff and the defendant. How can the court acquire jurisdiction over the person of the plaintiff? Number 1, upon filing of the complaint and payment of the corresponding docket fee. Ano yung landmark decision dito? Sun Insurance Company Ltd versus Judge Maximiano Asuncion. How can the court acquire jurisdiction over the person of the defendant? Dalawa. Okay? Valid. Okay. Pinaggigit-gitan ko yung word na valid service of summons and voluntary appearance. May ikli lang. Huwag niyong masyadong hahabaan. Now dito may nalilito. How about jurisdiction over the issue or issues? Can it be conferred by the party? The answer is yes. Where do you get the issue? From the complaint. And of course, from the answer din. Magkakaroon ng pre-trial to define ano ba yung issue itatry natin dito. Okay? Now, pre-trial shall be correlated with Rule 34 and 35. Now, under Section 10 ng Rule 18, after the pre-trial question, can there be judgment? Or can the case be submitted for judgment? Now, the answer is yes. Ano yung 34? Judgment on the pleadings. If the answer does not tender an issue, then it can be submitted for decision. Remember, under Rule 7, Sections 3 and 6, okay, as you file your complaint, nandoon na yung testimonial mo via judicial affidavit. Nandoon na yung documentary mo, nandoon na yung object. The same thing with the answer. Okay? So, the purpose, according to Chief Justice Dado Peralta, para pabilisin. Now, when is an answer does not tender an issue? Okay. Doon naman sa isa kasi, summary judgment, there is an issue. But the issue remaining to be resolved is only insofar as damages are concerned. So, pwede lang i-determine ng court. Doon naman sa judgment on the pleadings, the answer does not tender an issue. Reason, there was no specific denial. When can there be specific denial? How do you deny an allegation? Is it enough that you state thereat that defendant denied the allegation in paragraph 5 of the complaint? Answer, no. While you deny, you need to specifically deny, state for the record why you are denying. Defendant denies the allegation in paragraph 3 of the complaint. Defendant has no personal knowledge sufficient to form a belief as to the truthfulness thereof, period. The truth of the matter is, then in that case, you specifically deny. Now, negative pregnant. Okay? Ano ba yung negative pregnant? Now, you deny, even if you deny, there was an acceptance or admission on your part, and therefore it is considered negative pregnant. So take note of that. Liberal construction sa Rule 1, ang Section 6 paboritong-paborito. Laging itinatanong, can you invoke liberality without compliance? Ano sabi ng Supreme Court? Invocation of liberal construction is not a magic wand. O banggitin nyo yan sa sagot nyo. So, there must first be a compliance bago ka, before you invoke a liberal construction. Lucban versus Morales, February 12, 2020, Mr. Justice Kagiwa. So, random natin titingnan. Now, question. Is lack of cause of action a ground for motion to dismiss? Baka ilabas sa problem. Answer, no. Reason. Di ba sinabi ko na kanina, kaya inuulit-ulit ko, kasi baka lituhin kayo ng examiner, wala na. Wala nang motion to dismiss, deleted and or transpose. Okay, memorize. Section 12, letter A, 1 to 3, Rule 15, lack of jurisdiction of the subject matter, litis pendentia, res judicata, and prescription. Now, all other grounds shall be alleged as affirmative defenses. Okay, parties to a civil action, only natural and juridical persons. Baka mamaya may sumagot sa inyo, plaintiff, defendant. Magagalit ang examiner. Hindi niya dapat maging abogado ko. Loko-loko ka ba? Ikaw lang mag-isa magdidemanda, wala ka naman dinidemanda. So take note, only natural and juridical person can be parties to a civil action. So take note of that. Yung iba, medyo yan nyo lang yung sagot. Huwag masyadong napakahaba na. Yun lang naman ang tinatanong. Okay, venue. Now, real, walang problema doon. Where the property situated. Okay, personal, at the option of the plaintiff. Where the plaintiff resides or where the defendant resides. Then, at the option of the plaintiff. Now, ito yung problem. A, obtain a loan from B in the amount of 50 million. Million na tayo ngayon. Okay, nung araw, panahon namin, 1,000 lang. Okay, ngayon million kasi nakita nyo naman yung jurisdiction na bago. Okay, obtain a loan from B, 50 million pesos, mortgage his mansion located at 12th Street, New Manila, Quezon City, and issued post-dated checks for the monthly amortization. The loan is payable for 5 years. In view of the pandemic, a suffered business losses that leads to the foreclosure by the bank, extrajudicial foreclosure under Act number 3135. Okay? Now, after the foreclosure, during the auction sale, it was only bidded upon at 45 million, leaving the amount of 5 million pesos. The bank is located or with principal office in Makati City. The bank filed a deficiency claim in the amount of 5 million pesos. Question, is the venue proper? Now, the answer is yes, because the action now is considered as personal action, no longer a real action. Real action, it has to be foreclosed in Quezon City. Kasi New Manila, 12th Street located in Quezon City. So, abangan nyo yung ganong problem, kasi nakakalito din yon. Pwedeng tama ka, nakita mo, mali ito. Pero yung pala talaga ang sagot. Okay? So take note of that. Baka sakali lang na magtanong ngayon. Okay. Now, dito laging tinatanong, verification and certification. Section 4 and 5, Rule 7, hindi nagbago. Now remember, not all pleadings are required to be verified. And verification can be corrected. Okay? It is not true with certification. Okay? Because every initiatory pleading shall be accompanied by a certificate of non-forum shopping. This is to assure the court that you are not filing multiple suits. Non-compliance with the certification requirement is a ground for motu proprio dismissal with sanction to the counsel or parties. Now, what pleading is required to be verified, always verified, or in what kind of proceedings that all pleadings is required to be verified? Pleadings submitted in cases of summary procedure, all pleadings shall be verified. So take note, yung forum shopping is a dangerous one. Nandun na rin yan sa kaso ng Dilima versus Guerrero. Na penalize yung notary public at that time. Okay? So take note. Now, How about how to contest document? When is a document actionable? So, if the action or defense of the defendant is based on the document attached to the complaint by the plaintiff, then it is considered as an actionable document and therefore it shall be denied under oath. So, kailangan may affidavit ka. Young Builders Corporation versus Benson Industries Incorporated. June 19, 2019 by Mr. Justice Kagiwa. So baka ano natin. Okay, supplemental and amended. Okay, amended, you can amend the complaint before the defendant filed his responsive pleading. It is a matter of right. Okay? It supersedes the original complaint. Now, in supplemental complaint, it does not supersede. It is merely by adding, striking an allegation or correcting a mistake. The original complaint is still stands. Now, nag-start, kung titingnan ninyo ang amendments, amendments starts from Rule 6 up to 35 lang naman. Yun ang naamyendahan. Okay? Now, filing. Doon muna tayo sa pleadings. Filing of origin or filing of complaint or answer. Di ba? Marami ng modes of filing ngayon. Okay? May personal, registered, dati na yan. Accredited courier. So, ano yung accredited courier? Ninja ban. And electronic mail. Now, mayroong kaso na na-interpret na ang Supreme Court. Barroso versus Commission on Audit. Okay? April 27, 2021, in bank decision. Pagka initiatory pleading, like complaint, it cannot be filed even by accredited courier. Now, you can file it personally or conventionally. Now, ano ba yung reason dito? Because you need to pay the corresponding docket fee. But the Supreme Court, kumambyo. Pwedeng registered mail. Now, remember, nagkaroon na ng mga e-filing ngayon. Also, payment sa bangko. But not all courts throughout the Philippines ay pupwedeng ganon. Mayroong mga court na hindi covered. Now, bakit inalaw ng Supreme Court ang Barroso versus COA na pwedeng registered? Because class, pwede ka kasing magbayad sa post office through money order. So take note of Barroso versus Commission on Audit. Hindi pwedeng initiatory pleading. You file it through accredited courier. Now, while it is true na allow na, okay, difference, registered mail, accredited courier, the date of mailing is the date of filing. So if your last day is October 15, 2022, you mailed it at 4:30 in the afternoon. The stamp mark date thereon is the date of filing. Okay. Kapag ka ordinary mail or through non-accredited private courier, it is the actual receipt. And therefore, if you file it October 15, it was received October 17 or October 16, you are late by 1 day. So take note of that. Yung manner of filing ng pleadings. Okay, summons. Okay, may isang ano rito na ano ko lang, baka mamaya maitanong. Does PAW have the authority to serve summons? Kasi medyo lumaki pangalan ng Public Attorney's Office ngayon. So pwede kaya na yung PAW ang mag-serve ng summons? Now the answer is yes. Officials and employees of the Public Attorney's Office are authorized to serve summons, subpoenas, and other court processes on behalf of their clients. So this is the letter of Chief Public Attorney Presida Rueda Acosta to the Supreme Court under AM number 11-10-03-0. Matagal na to. July 30, 2013, in bank resolution of the Supreme Court. So wag niyong kalimutan, baka magtanong ngayon. Now, omnibus motion. Okay? Now, is motion to dismiss considered as an omnibus motion? Answer yes. Kasi kung titingnan ninyo class, ang definition ng omnibus motion, it attacks an order, resolution, judgment, and pleadings. So pleading, the first pleading of a plaintiff is the complaint. So if you file a motion to dismiss, it is considered as an omnibus motion. Now itong kasong ito, sikat din, lagi kong sinasabi pagka nagle-lecture ako. Now, prior to the amendment kasi, a motion without a notice of hearing is considered as a mere scratch of paper. Okay? So nagkaroon ng landmark decision dito. Sa ngayon, whether the motion is litigious, pag sinabi mong litigious, it affects the substantial right of the adverse party. Pag sinabi mong non-litigious, it does not affect the substantial right of the adverse party. And therefore, you may not set it for hearing. Effective May 1 of 2020, litigious or non-litigious motion need not be set for hearing. The court will be the one to set it for hearing. Now, yung sinasabi kong decision prior to the effectivity of the new rule was the case of Laude versus Sinesa Balde. Okay? So the Philippines and the United States has a visiting forces agreement. Okay? So annually, nagkakaroon ng military exercises. Now, it is a public knowledge and even of judicial knowledge that if these American GIs are on R&R, then they will color the city or they will paint the city red. So nung nangyari yon, dumaong yung barko sa Subic, dating US military base. Now, one of the GIs, American personnel, was Pemberton. Okay, so lumabas sila, nag-R&R, naglalakad siya along Magsaysay Avenue sa Olongapo. Okay, so nakita niya ngayon si Jennifer Laude. Kung naalala ninyo, sikat na kasong yan. Na dating Jeffrey. Okay? So nung nakita sila, di nakita niya maganda. So sabi niya, hey beautiful, you want to play jackstone? Sabi niya. Akala siguro magja-jackstone sila. Sumama naman. So nag-inuman. Then after nilang uminom, nag-check-in sila sa Jackson Lodge. Okay? So naghubad na ngayon si Pemberton. Pemberton was young, macho guapito, American. Ano pa lang, 21 pa lang yata at that time. So nagubad din yung Jennifer. So pagubad ngayon ng Jennifer, tumingin sa baba si Pemberton, nakita niya may lawit siya. Pagtingin niya kay Jennifer, may nakatali din, lawit din. Nagalit. Sabi niya, hey, we will not be playing fencing here. Sinabunutan niya, isinubsob doon sa inodoro, pardon my word, nalunod, patay. So a case for murder was filed against Pemberton. Now, under the BFA, if an American GI committed a crime in the host country and the crime committed is a non-bailable offense, pending trial, he shall be detained at the Marine Barracks. And at that time, it was in Taguig, Metro Manila. So in the meantime, dinitain siya doon. So kumuha ng private prosecutor yung pamilya ni Jennifer Laude. Nag-file ng motion to transfer detention without the prior conformity of the city prosecutor of Olongapo City. Number one. Number two, there was a violation of the 3 days notice rule. Under the old rule, there must be at least 3 days notice to the adverse party. So, kung nakadyo yan ng Huwebes, at least Lunes i-file mo na. Or Friday, at least Martes i-file mo na. Ipadala mo doon sa kabila. To see to it that you have a 3 days notice to him na mabibistahan mo. So, it was objected to by the counsel for Pemberton. The court denies it. Number 1, violation of the 3 days notice rule. And number 2, violation of Section 5 of 110 of the 2000 Rules of Criminal Procedure. They go to the Supreme Court on certiorari under Rule 65. Grave abuse. Ano sabi ng Supreme Court? A motion without a notice of hearing is a mere scratch of paper. Now, prosecution or criminal cases shall be prosecuted under the direct control and supervision of the city or provincial prosecutor. So it was denied. It was classed the leading case before sa 3 days notice rule. Until now, it is still the leading case under Section 5 of 110 of the 2000 Rules of Criminal Procedure. Okay. Dismissal of actions. Okay? Dismissal due to the fault of the plaintiff. So, there is a rule o 2 dismissal rules. Pag nakadalawa ka, you can no longer refile it. Now, ano yung correct word if it is due to the fault of the plaintiff? If the plaintiff failed to prosecute for an unreasonable length of time, it is a ground for dismissal. Okay. The examiner will be attracted with your answer when you utilize the word non-prosecutor. Okay? Non-prosecutor. Okay? Intervention. When can a party intervene? It must be done before judgment. Okay? As a rule, after judgment, you can no longer intervene. You versus Miranda, March 27, 2019. So take note. Okay. Modes of discovery. Ito maganda rin i-discuss. Baka ilabas either sa criminal procedure or sa civil procedure. Now remember, yung modes of discovery, 23 to 29. May dalawang kaso rito. Yung Go et al. Versus People nangyari sa Manila. Hindi pwede ang modes of discovery. You cannot, the testimony of the witness cannot be taken outside of the territorial jurisdiction of the court. Okay? So it must be taken before the judge where the case is pending. It was in 2012. Pagdating ngayon ng 2019, nagkaroon ng panibagong kaso. This is the case of People versus Serio and Lacanilao. Ano nangyari dito? So, si Mary Jane Biloso was recruited to work in KL, Kuala Lumpur, Malaysia. Okay? Recruited by Serio and Lacanilao. Upon arrival in Kuala Lumpur, wala daw employer. So, nagkaroon ng instruction sa kanya na kinakailangan daw mag-exit muna siya ng KL. And she was told to go to Yogyakarta, Indonesia. Ngayon, pagpunta niya, nagpadala ng luggage. Okay? Without much question, dinala naman ni Mary Jane. Pagdating niya ng Yogyakarta Airport, she was apprehended. And when the luggage was opened, there is a 2.5 kilos of cocaine. So, she was prosecuted and sentenced by firing squad. Okay? Kasi death penalty sa Indonesia. In the meantime, the NBI filed a case for violation of the Migrants Workers Act, violation of the Anti-Trafficking in Persons Act, violation of Article 315, Paragraph 2A of the Penal Code. Okay? So it was filed with the RTC of Santo Domingo, Nueva Ecija. In the meantime, the prosecution filed a petition, filed a motion to take the position of Mary Jane. Objected to by the defense, then reversed by the Court of Appeals, then elevated to the Supreme Court. This time, the Supreme Court made a 180 degrees turnaround. It says that deposition can be done, and the testimony of Mary Jane is likened to a dying declaration. So sabi ng Supreme Court, if in dying declaration, it is one of the 13 exceptions under the hearsay rule, much more that this testimony can be allowed. For the reason that the judge will be the one to take the direct testimony of Mary Jane, cross-examination will be propounded also in writing because the Indonesian government made a condition You can take the deposition inside the jail to be taken by one person only, no camera, no radio, no other. So therefore, the judge will be given a first-hand information and personal in character. So pagka tinanong kayo tungkol sa deposition sa criminal cases, because it is governed by Section 15 of 119, banggitin nyo yung kaso ng People versus Serio and Lacanilao. Now, another one, can the judge delegate the reception of an ex parte evidence to his or her branch clerk of court? While it is true that in civil cases, it can be delegated to the clerk of court who is a member of the bar, you cannot delegate the reception of evidence to the clerk of court. So this is the case of judicial and rejudicial audit conducted in the RTC, Branch 20 of Cagayan de Oro City, in Misamis Oriental. Okay? So in-bank decision, no delegation of reception of evidence ex parte to the branch clerk of court, even if the branch clerk of court is a member of the bar. Okay. Demurrer to evidence, Rule 33 in civil cases. Section 23, Rule 119 in criminal cases. Effect. So what is a demurrer to evidence? A demurrer to evidence is a motion to dismiss on the ground of insufficiency of evidence. What is the effect in civil cases if the demurrer is granted? So the case is dismissed. How about if it is reversed on appeal? The right of the defendant to present evidence is forfeited. It shall be decided based only on the complaint by the plaintiff. Now, kumpara na agad natin sa criminal. How about in criminal cases? So dalawang bagay. If the demurrer is filed without leave of court and it is denied, the right of the accused to present evidence is forfeited. If it is filed with leave of court and the same is denied, the accused is given a chance to present evidence. If the demurrer is granted, it is equivalent to acquittal. Okay? So yung tatlong instances na yon, dapat alam na natin. So na-discuss ko na yung judgment on the pleadings. Na-discuss ko na rin yung summary judgment. Okay. Punta tayo doon sa 39. Okay. List down the following. Okay. Under Rule 39, class, ito yung pinakamahaba. There are 48 sections. Okay. Ano lang ang tatandaanan mo sa 39? Kasi all others, trabaho yan ng sheriff. Hindi kayo nandito na magbabar para maging sheriff. Although, pag naging clerk of court ka, ikaw din ang pinakamataas na sheriff. Kaya pag nakita ninyo sa opisina ng clerk of court, ang nakalagay, Office of the Clerk of Court and ex officio sheriff. Okay? But for purposes of the bar examination, remember the following. Sections 1, 2, 6 o 5 and 6. Okay? 11, 47, and 48. Now, doon sa section 1, wala kang problema. Once a decision becomes final and executory, matter of right, compellable by mandamus. So, ministerial duty kasi ng judge. Okay? So, pag nabanggit mo kasi yung mandamus, tatlong magkakapatid yan. Certiorari, prohibition, mandamus. Ang naiiba lang si mandamus. You can only utilize mandamus if the duty of the public officer, board, body ay ministerial. Pag hindi ministerial, automatic yun, i-deny yun ng court. Okay? So doon sa certiorari, 14 elements. Binanggit ko na kanina. Prohibition, ganun din. So madali yung ma-distinguish. Excuse me. Okay. So, let us continue. So, matter of right. Now, doon sa pangalawa, discretionary execution. Okay? So, what is required in discretionary execution? Posting of a bond. Because in other words, class, the decision is not yet final and executory. Now, Section 2 of Rule 39 has been adopted by the Commission on election protest cases. Now, before the election of 2022 in May, naglabas ang Supreme Court ng rules of election contest in the municipal level. Because in case of election protest, you file it with the RTC pagka municipal officials. Okay? Kapag city, provincial, regional, national, COMELEC. Now, the decision of the RTC is appealable to the COMELEC, not to the Court of Appeals, as an exception to the rule. So, pwedeng inadapt nila yon. And usually, yun ang ginagamit pagka nagpapa-execute. There must be, one of the requirement is there must be good reasons. Example, municipal mayor has a short term of 3 years. So it can be executed. Now, payment of docket fee. And number 3, posting of a bond. Now, what is the purpose of the posting of the bond? The posting of the bond class is answerable to any damages that may be incurred in the implementation of the writ of execution. Okay. Lifetime of the writ of execution. 5 years by motion, 5 years by action. Okay? Huwag niyong kalimutan yon. Repeat. 5 years by motion, 5 years by action. Now, what does it mean? Now, it means, class, that after the issuance of the writ of execution, it has a lifetime of 5 years. After the lap of the 5-year period, it becomes punctus officio. Question, can you file a motion for reissuance of alias writ of execution? Answer, no. What should you do? You file a motion for revival of judgment. After the revival of judgment, you can now file a motion for reissuance of alias writ of execution. Okay? Now, a special judgment under Section 11. Section. Ito naman Section 11. Now, if the sheriff is armed with a writ of execution for recovery of property, ownership, or possession, and after serving the notice to vacate, the occupants failed to do so, now, can the sheriff now, with his demolition men, demolish the structure to regain possession or regain the ownership of the property and delivered it to the plaintiff? Answer, no. There must be a special judgment. Then what is that? You need to file a motion for issuance of writ of demolition. Now, in case of absence, to that effect, the sheriff could be held criminally liable for grave coercion. Okay? So, clear tayo doon. Now, ano ngayon ang mabenta? Yung Section 48. Foreign judgment. So, A, married B, a Japanese national and a millionaire. The reception was taken at Manila Hotel, and the marriage was solemnized in Manila Cathedral. B spent around 15 million pesos. After their marriage, A and B went to Sasebo, Japan. And after 15 years of marriage, filed a divorce. Now, in Japan, the divorce decree is only signed by the civil registrar. So after obtaining a divorce decree, 50% of the wealth of B was given to A. Then A went back to Nueva Ecija in Cabanatuan. Now, A approached you that she will be marrying her childhood sweetheart, and she wants that the divorce decree be recognized. Okay? So if you are the counsel of A, what is your remedy? O what should you do? Kasi pwedeng problem, puro problem ang ibinibigay ngayon. Analysis mo. Okay? Now, can the divorce decree be recognized in the Philippines? Answer, yes. Now, dun sa problem, maikli lang. Pero may involved na jurisdiction. Where will you file it? Of course, you file it with the RTC designated as a special family court. In the absence of a special family court of the RTC, the regular RTC has jurisdiction. Reason, it has general jurisdiction. Then you can utilize Section 48 of Rule 39. You can file a petition for recognition of foreign judgment. Remember that the judgment or the divorce decree, dalawa lang ang recognized na language natin sa Pilipinas. English and Filipino. So it must be or accompanied by official translation. So you can attach it and you can file it in a special family court. Okay. Now, another one class is Section 47. Okay? Effect of final judgments or final order. Remember that res judicata is a ground for motion to dismiss. So, what does res judicata mean? A matter adjudged, and therefore it cannot be re-litigated upon for the second time. People versus Caminporte et al. June 14, 2021. Mr. Justice Kagiwa. Nagpahabol pa to. Then another case, Republic versus Rogosa Development Corporation, April 3, 2019. Now, conclusiveness of judgment. What does conclusiveness of judgment means? So, it is conclusive and continues to be binding between the same parties, their previous and successors in interest, as long as the facts which the judgment predicated continue to be the facts of the case or incident before the court in a later case. Okay? So take note of those principles. Okay. Now, preliminary attachment, dalawa patamaan. 57 civil, 127 criminal. But if you read 127, kasama. Nagre-refer siya sa 57. Remember that attachment is only an ancillary remedy. It is not an independent action, and therefore it is dependent to the main action. There could be no attachment when there is no main action. You versus Miranda, March 27, 2019. Okay. Hindi ko na diniscuss yung 40 to 45 kasi ito na yon. Yung doon sa Moya 3 para mas madali nyong maintindihan. As much as possible gusto kong makover. Okay? Kaya hindi ko na diniscuss. Okay. Rule 58, injunction. Okay? Prohibitory, mandatory. Okay. Ano yung pinaka-crucial na provision? Section 5. Okay? Lifetime of a TRO. RTC 20, Court of Appeal 60, Supreme Court until it is lifted. Okay. Within the 20-day period, the court must conduct a hearing. Whether it is an application for prohibitory or mandatory injunction. After the lapse of the 20 days or 60 days period and no injunction is issued, then it is automatically dissolved. Now, how about if due to the urgency of the matter and there is a irreparable or irremediable injury that the petitioner may suffer if the court will not act to do so, and the court issued a 72-hour TRO question, will it be deducted from the 20-day period or it will be added? It will be deducted in a multiple sala court or in a single sala court. So take note of that. Yung 72-hour period, i-deduct kung mag-i-issue. Okay. Now, if the Supreme Court is the one who issued the TRO and or injunction or status quo anti-order, then it has no period unless it is stated in the order of the Supreme Court. Now, ano yung landmark decision dito? Okay? That it is a condition sine qua non for the petitioner to post a bond. Okay? Now, pareho din yun doon sa attachment. It is also a condition sine qua non. Mas sikat nga lang yung Rule 58 kasi laging ginagamit. So this is the case class of PGMA versus Secretary Laila de Lima. Ano ba nangyari doon? So PGMA was one of the accused for plunder before the Sandigang Bayan. The reason that she affixed her signature and state in the request for additional intelligence fund of 344 million the word okay. Now, in view of the medical condition, nag-file ngayon si PGMA ng motion that she be allowed to travel to West Germany for medical treatment. It was denied by the Sandigang Bayan and elevated to the Supreme Court. Now, when it was elevated to the Supreme Court, it was granted and an injunction was issued by the Supreme Court subject to the posting of 1 million bond. Okay. So, since she is a former president, may courtesy yung mga airlines. So, nakakuha naman agad. Now, while they are already at NAIA, she was stopped by the immigration officer upon instruction allegedly by the Secretary of Justice. Kasi tinanong, saan po yung piyansa nyo? Now, allegedly, yung tao ni PGMA arrived in the Supreme Court around 3:30, magpo-4 na. Yung bayaran doon hanggang alas 3 lang. Bakit? Kasi nga yung pera, dinideposito yan sa land bank. Okay? So, hindi ngayon na i-deposito yung 1 million. So, PGMA filed a petition under Rule 71 against Secretary de Lima. It was dismissed by the Supreme Court. The Supreme Court said that the effectivity of the injunction is conditioned on the posting of a bond. So take note. So makakakuha na siguro tayo ng baka makakakuha na tayo ng mga possible na tanong doon. Okay, certiorari prohibition, mandamos, I already discussed this. Tatandaan na natin yung sa certiorari, i-cite nyo yung 14 elements. Now, what is the sole office of the writ of certiorari? Now, it is the office of the certiorari to correct errors of jurisdiction and not error of judgment. Now, what is the reason? Because if it is error of judgment, the remedy class is appeal. Kaya nga, ang sabi ko sa inyo, tingnan nyo yung caudal ninyo, ang nakalagay dyan, appeal, sa Rule 45. Ang certiorari, ang tawag doon, petition for certiorari. It is an original action. Again, sikat uli si de Lima dito. Ito yung kaso ng inmates of the new Bilibid prisons versus Secretary de Lima. Di ba, yung RGTCA, it was given retroactive effect. Nag-issue kasi ng IRR jointly ang DILG saka ang DOJ na ang effectivity raw ay prospective lang daw yung effect. Hindi retroactive. So that is in violation of the provision of the revised penal code that no law shall have retroactive effect unless it is favorable to the accused. Okay. Now, concept of grave abuse. So, there is grave abuse class when there is evasion of positive duty or virtual refusal to perform a duty. So, yun ang ibig sabihin ng grave abuse. Now, if you can memorize it word for word, the better. If not, yun lang ang importante na gustong mabasa ng examiner. Evasion of positive duty or virtual refusal to perform a duty. So kailangan nakasulat yon. Now how about prohibition? So it is to prevent the unlawful and oppressive exercise of authority. Yung word na unlawful and oppressive exercise of authority. So anong sabi since we were in our first year law proper? Write like a lawyer, speak like a lawyer, if you want to become a lawyer. Now, yung mga examiner, may gusto lang silang makita doon. Na makonvince mo sila that you are worthy to become member of the bar. Kasi ito lang ang professional examination na masyadong celebrated. Nagkakagulo ang buong Pilipinas. Hindi naman ganyan pagka-examine ng doktor. Hindi naman ganyan kung nag-examine yung mga engineer, nurses, etc. And this is the only professional examination administered by the highest court of the land. So, write like a lawyer, speak like a lawyer. Now, mandamos. You can only avail mandamos if the duty is ministerial in character. Balmores versus Atchacoso. Mr. Justice Kagiwa, July 19, 2017. Kabigao versus Comelec. In-bank decision. So, possible na magtanong dito. Now, punta tayo sa expropriation kasi di ba yung programa ni President Digong ay build. Okay? Now, expropriation clause is only the implementing rule by the Supreme Court. No private property shall be taken for public use without payment of just compensation. So this is the exercise of the state of eminent domain. So this is inherent power on the part of the state. Now, dito pwedeng magkaroon ng problem sa expropriation. There is a distinction clause if the project is national in character under 8974 and if it is local. So under 8974, no TRO can be issued by any court for government national infrastructure projects except the Supreme Court. So kailangan umakyat ka. This is an exception to the rule. Kung mag-a-apply ka ng TRO. Now, hindi yun ang question. The question is, how about if it is a local project? Can you file a petition for issuance of temporary restraining order with the local RTC? The answer is yes. Yung 8974, pagka national lang iyon. So kapag ka local, pwede ka pa rin mag-avail ng TRO or injunction. Okay? Now, how about extrajudicial foreclosure of mortgage under Act 3135? Kasi class, birang-bihira na nagkakaroon ng judicial foreclosure under Rule 68. Pagka nangutang tayo sa bangko, pinapipirma ka ng promissory note and special power of attorney in favor of the bank pag nag-execute ka ng REM o real estate mortgage. That in case of non-payment, may dalawang remedy, minsan tatlo pa ang bangko. Kung nag-issue ka ng cheque, tumalbog, BP22. The bank can also go after you for collection sum of money based on the promissory note. And the bank can also foreclose the REM under Act 3135. Hindi sila nagro-rule 68. Now, ano yung elemento bago makapag-exercise ng 3135? Okay? There are 3 elements. Number 1, there is a failure to pay the loan. Number 2, it is secured by an REM. And more importantly, there must be a demand. Mandatory yung demand. Without demand, the mortgagor is not in delay. Okay, so yung tatlong elementong yun. Rodriguez versus Export and Industry Bank. June 14, 2021 by Mr. Justice Kagiwa. Okay? So take note of that. Makakarami na siguro tayo. Makabawi man lang. Kasi maraming umiiyak ngayon because of the examination in civil law. Okay? Now, punta tayo sa 70 partially discuss ko. Now, what are the 3 actions to recover possession? Ito lang tandaan na ninyo. Okay? Now, 1 is action interdictal or summary ejectment proceeding. So yung ejectment tulad nung nasabi ko kanina ay 2 klase. Isang forcible entry, otherwise known as detentasyon, at isang unlawful detainer, otherwise known as desahucio. Now, the condition is disposition has not lasted for more than 1 year. Okay? Jurisdiction belongs to the MTC. Okay? Now, action publiciana. Okay? To recover a better possession and the possession have lasted for more than 1 year and therefore the jurisdiction belongs to the RTC. Okay? And the third one is action reinvindicatoria. Okay? Action for recovery of ownership. So you have Collado versus Gutierrez 2019 in bank July 30, 2019. So in other words, pwede ring itanong ito in a form of a problem kung ayaw magtanong ng enumeration ng examiner. Kasi yun yata ang bilin ni Justice Kagiwa. To test paano kayo sumagot on a certain problem. Kasi nga naman, yung kaso ay problem pag nag-file ka ng answer. But you need to know what are the principles, what are the laws involved, what are the decisions that you can use. In fact, nasa pre-trial brief mo yun, ilinalagay nga yun. Doon mo rin kukunin yan sa complaint mo. Okay. Now, bago ko makalimutan, okay, baka sakali, relief from judgment under Rule 38, magkakapatid yan. Post-judgment remedies. Relief under Rule 38, then annulment of judgment under Rule 47, and the last one is Rule 65. Bakit sinasabi kasi na post-judgment? Kasi class, nagkaroon na ng decision. Remember, a decision becomes final and executory after the lapse of the 15-day period. Now, doon tayo sa relief. Ano ang importanteng malaman mo doon? Number 1, grounds. Ano yung grounds? PAMEN. Fraud, accident, mistake, excusable, negligence. Okay. Now, pangalawa na dapat alam mo, prescriptive period. Section 3. 60 days from learning and 6 months from entry. Okay, dapat alam mo yon. Within that span of time. Now, saan usually nangyayari ito? It usually happen in case of declaration of in default. Meaning, there was a failure on the part of the defendant to file a responsive pleading or answer within the period. Now, kapag hindi po pwede sa 38, may isa pang remedy. Okay? Annulment of judgment. Rule 47. Again, ano ang ground mo doon? Lack of jurisdiction, extrinsic fraud, and per jurisprudence, lack of due process. Okay. Prescriptive period, 4 years from discovery, unless it is barred by laches or estoppel. Now remember that Rule 47 is the last equitable remedy. Okay. Dito pwedeng magkaroon ng problem. I-correlate natin doon sa Rule 70. Naalala ko lang, yung sa contempt kasi class, madali. Direct saka indirect lang yun. Ngayon, pagka nagtanong doon sa contempt, what is the nature of a contempt proceedings? Is it a criminal or civil in character? Ano ang dapat na mabasa ng examiner? While the proceedings is civil, it is akin to a criminal proceedings. In view of the danger that you can be incarcerated and you need to pay a fine or both. Okay, balik ako. Okay? So, 47 in relation doon sa 70 na problema. So, A filed an ejectment suit with the MTC against B. However, the possession or dispossession has lasted for almost 4 years. So, when the MTC issued a judgment, A filed a petition for annulment of judgment with the RTC. Okay, the question is, can the RTC, instead of ordering the dismissal of the case, in view of lack of jurisdiction, and therefore the decision is null and void and has no force in effect, can the RTC assume jurisdiction? Now, the answer is yes. Because jurisdiction or original jurisdiction belongs to the RTC because of the disposition has lasted for more than 1 year. Now, annulment of judgment class is merely, if granted, is merely a renewal of litigation. Uulit lang kayo. Kasi nga, ang ground mo doon, extrinsic fraud, lack of jurisdiction, and lack of due process. Now, also, another principle to remember, annulment of judgment is only up to the Court of Appeals. Okay? MTC to the RTC, RTC up to the Court of Appeals. The Supreme Court class has no jurisdiction under Rule 47. Hanggang Court of Appeals lamang yan. Now, i-deviate ko ulit doon sa Rule 70. Okay? Now, remember, from MTC, going to the RTC, you can stop the execution. Kasi as a rule, being covered by the rules of summary procedure, the decision is immediately final and executory. Now, how to stop? Number 1, filing of notice of appeal. Number 2, payment of docket fee. And number 3, there is a posting of a supersedeas bond. Now, the implementation of the decision can only be made up to the RTC. Okay? Now, Section 19 in relation to Section 21 of Rule 70. Now, if the case is in the RTC or in the Court of Appeals or the Supreme Court, you can only stop the execution if the Court of Appeals or the Supreme Court issued a TRO and or injunction. Absent any TRO or injunction, the execution can no longer be stopped. Okay. Palalain ko uli yung problema. Now, how about if the decision was already executed? On appeal to the Court of Appeals or to the Supreme Court, it was reversed. What is the remedy? Reparation of damages. Okay? So, take note of that. So, yan kasi class, connect yan. The technique in studying law is correlation. Kung nako-correlate mo, makakatipid ka ng oras. Okay? Kaya nga, dinugtong-dugtong na natin. Okay. Now, referral for conciliation. Is it a ground for the dismissal of the case? So, it was answered in the case of Belbis, Spouses Belbis versus Spouses Conrado, July 24, 2019, Mr. Justice Kagiwa. The answer is no. The case will just be held in abeyance pending compliance. Okay? So, pending compliance. Now, by the way, is good faith a defense in a contempt proceeding? Now, the answer is yes. Because in contempt, the intent goes to the gravamen of the offense. If the party is acting in good faith, now he is within his rights. The presence or absence of a contumacious intent is determinable whether you will be cited in contempt or not. Okay? Now, doon sa appeal, ang tatandaanan ninyo yung 122 sa criminal cases saka 124. Okay? Now, kapag ang penalty ay reclusion perpetua or life imprisonment from the Court of Appeals going to the Supreme Court Notice of Appeal under the doctrine of double appellate review. So wag natin kalimutan yon. Now, yung appeal naman, 40 to 45, na-illustrate na natin, hindi nag-iiba. NAPIS rule also applies in criminal cases. Ano yung decision? You versus Tatad. So much for civil procedure. Punta muna ako kasi na-discuss ko na pahapyaw. Meron na akong na-discuss. Ay, mayroon pala, baka makalimutan ko. Material data rule. So, kailan ba nagkakaroon? In what cases does the material data rule applies? So, nag-a-apply ito, class, sa appealed cases, including Rule 65. Now, ano ba yung material data rule? Now, the petitioner needs to state in his petition or appeal by certiorari the following dates. Number 1, date when notice of judgment or final order or resolution was received by the petitioner. Number 2, the date when the motion for reconsideration or new trial was filed. Kasi condition sine qua non yun. And number 3, the date when the notice of denial was received by the petitioner. So yung tatlong yun, material data rule. Repeat. So in appeal cases, including a Rule 65 petition, the following dates must appear in the petition. 1, the date of notice of judgment, order, or resolution was received by the petitioner. Number 2, the date when the motion for recon or new trial was filed. And number 3, the date when the notice of the denial of the motion for reconsideration or new trial was received. Okay? So, material data rule. Now, writ of execution. Balikan ko lang. Because this is also discussed under Rule 51 as a judgment. Now, in what portion of the decision needs to be stated in the writ of execution? So, it is the dispositive portion. Not the body of the decision, but the dispositive portion. Okay? So, complaint of Judge Rodolfo Garcia against the 18th Division Clerk of Court of the Court of Appeals. This is an old case, March 20, 2012. However, this is an in-bank decision. Now, Supreme Court. Okay? So, kung titingnan ninyo, class, yung Court of Appeals is governed by Rule 46. Original action. Pag tiningnan nyo na naman, yung Rule 56, nahahati sa dalawa. Ano napansin nyo? Pareho silang ending sa 6. Okay? So, sinadya yan para madali. Now, pagka sa Supreme Court, yung A, original action. Ano to? Certiorari provision, mandamus, cowardo, habeas corpus, 3 special rules. Then, discipline for lawyers and judges and employees, etc. Okay? Doon mo direktang ipapile yun. Pagdating mo doon sa 56B, appealed cases. Okay? So, tingnan ninyong maigi yung dalawang yun. And remember, you need also to correlate it with the jurisdiction of the RTC. Kasi concurrent silang tatlo. Now, you need to observe under the doctrine of judicial or hierarchy of courts. Kinakailangan yon. Now, I already discussed the case of Laya Jr. Versus Philippine Veterans Bank. Now, kung titingnan nyo, class, ang rules of court, second motion for recon is a prohibited pleading. Now, ano yung legal anchor ni Attorney Laya na gumamit siya ng second MR but it was not outrightly denied by the Supreme Court despite being a prohibited pleading? It is Section 3, Rule 15 of the internal rules of the Supreme Court. So, the Supreme Court can take cognizance of the second motion for reconsideration when the assailed decision is not only legally erroneous, but is likewise patently unjust and potently capable of causing unwarranted and immediate injury or damage to the party. Okay? So, internal rules. So, if a question is asked, what is your legal ground? Wag mo nang i-memorize yung Section 3, Rule 15. Baka mamaya magkamali ka pa. Then, ang sabihin mo, based on the internal rules of the Supreme Court. Okay? Pwede bang mag-break muna? Inom lang ako ng tubig.
Sige po, Dean.
Stressed out? Wishing for new ways to learn and master codal provisions? Codify makes it easy. With just a few taps, you can customize and select the tracks to memorize or study further. With Codify's Playlist Manager, choose from the subjects and create your own playlist. Imagine your own law track. Experience studying the law anytime, anywhere. Fortify learning with Codify. Meet your new learning buddy. Download Codify now. Achieve your learning goals, one track at a time. Listen and learn with Codify. Get the app today. Your first 7 days are on us.
resume. Okay, para ma-cover natin, criminal procedure muna tayo. So 110 hanggang 127. Although na-discuss na rin natin dito, specifically yung appeal. Okay, archiving of cases. What does it mean? So it means it is designed to shelve cases but it's done only if there is no immediate action expected. Ano yung landmark decision dito that leads to the dismissal from the service of a judge? So this is the case of Marcos versus Cabrera Pallier, January 24, 2017 in bank per curiam. Okay? When can a case be archived? Ano ba kasi nangyari dito? So nagkaroon ng initiation from a fraternity in San Beda. So namatay si Andre Marcos. So pamangkin siya of my good friend and co-professor of the Tarlac State University School of Law and also grandson of the late Judge Marcos. Okay? So ano ba nangyari? After the issuance of the warrant, in-archive niya yung kaso. So ganun lang. So a case was filed against her kasi there was violation of Administrative Matter 7-A-92. Now, this is the guidelines issued by the Supreme Court if a case is to be archived. So number one, na guidelines dito, after the issuance of the warrant of arrest, the accused could not be arrested or remains at large for 6 months. Hindi naman. Okay? Pangalawa, proceedings are ordered suspended for an indefinite period by a higher court. Wala naman. Then the accused appears to be suffering from an unsound mind or mental disorder. Hindi naman. Then interlocutory order incident to the criminal case is elevated and pending resolution by the higher court. Hindi naman dito. Or the accused jumps bail. So, wala dito sa guidelines na inisyu ng Supreme Court, but on her own, Judge Cabrera Pallier issued an order to archive the criminal case. So the Supreme Court said there was violation, gross ignorance of the law. Now, remember, jurisdiction in criminal cases, venue is jurisdictional. Where the crime was committed. Exception to the rule. If the crime committed is transitory in character. Ano yung example nito? Kidnapping. BP22, nag-issue ng cheque sa Manila, iningkas sa Baguio o dineposit sa Baguio, tumalbog. In any of those places that the check traveled, you can file. The filing of the case in one venue shall exclude any other venue. So take note of that. Now, can injunction be issued in a criminal case? Okay? General rule, no. Exception to the rule. When there is grave abuse of discretion amounting to lack or excess of jurisdiction. Okay, mabilisan lang ang discussion natin. Okay, 110, crucial, yung Section 5. Remember the case Ablaude versus Sinesabalde that all criminal cases shall be prosecuted under the direct control and supervision of the public prosecutor. Now, there is an old case which I think pwede pang magamit. It is still a good case, the case of Paquillo versus Tolentino. Now, under 112, no information or complaint can be dismissed or be filed without the prior conformity of the city or provincial prosecutor. Now, in Paquillo, the regional state prosecutor of Region 5 conducted a PI, okay, for violation of the SSS law. The information was filed without the prior conformity of the city prosecutor of Naga or Camarines Sur for that matter. So the accused filed a motion to quash. It was denied and they reached up to the Supreme Court. The Supreme Court said, invoking 112, that there must be a prior conformity of the city or provincial prosecutor. Sometimes, class, nagkakaroon na ngayon ng order designating the signing of the information. So kapag ganon, valid yun. Pero kung wala, hindi po pwede. Okay? So, 111, ano naman ang crucial dito? Yung BP22. Now, criminal cases, a person criminal liable is also civilly liable. Under Section 1, paragraph A, the private complainant can reserve the institution of the civil action before the prosecution start presentation of evidence. But under paragraph B for BP22, when the information is filed, it includes the civil aspect of the case. There is no separate civil action. Now, Mandagan versus Jose Valero Corporation, June 19, 2019, by Mr. Justice Kagiwa. So hindi ka po pwedeng hiwalayin o ihiwalay ang pagpapile ng civil. Okay, pag ipinail mo yung BP22 sa cheque, kung 100 million yan, empty silang ang jurisdiction yan. So take note that if the crime committed is punishable by at least 4 years, 2 months in 1 day, PI is a matter of right. Therefore, if it is punishable less than 4 years, 2 months in 1 day, it is a matter of discretion. Now, effect of death of the accused on the civil action. This is otherwise known as the Bayotas Doctrine. People versus Bayotas. Okay? So, the death of the accused pending appeal. So, even if the accused is convicted, if the case is on appeal, pursuant to the case of in reconviction of Judge Adoracion Angeles, the presumption of innocence is still prevails. Okay? So, if the accused died pending appeal, and the source of the civil obligation class is the crime or was the crime committed, then it is totally extinguished. But if there is any other source or sources of civil obligation, it will survive the death of the accused. Example, if a mortgage is property to be amounting to 50 million pesos, payable in 5 years, then A issued post-dated checks for the payment, executed a promissory note and an REM. For failure to pay for 6 consecutive months, the bank filed violation of BP22 cases. While the case was ongoing, A suffered from COVID-19 and died. Question, can the civil aspect still survive? If despite the death of the accused, the answer is yes. Why? There are 2 sources of civil obligation, the promissory note and the REM. Now, suspension by a prejudicial question. So, there is no quibbling that if the result of the criminal case would be dependent to the result of the civil case, then there is a prejudicial question. The criminal case will be held in abeyance and the civil case or the criminal case will wait for the result of the civil case. Now, the question, hindi yun ang question. Kasi alam na alam nyo yun. Now, the question is, does the prejudicial question doctrine apply in civil cases? So, there is a case of Security Bank Corporation versus Victorio in 2005. Now, the Supreme Court said, while it is true that the prejudicial question applies only when there is a pending civil and criminal cases, however, if the result of the second case cannot be determined without the determination of the result in the first civil case, then the principle or the doctrine of prejudicial question can be applied. So this is also the ruling in the case of People versus Caminporte, June 14, 2021 by Mr. Justice Kagiwa. Okay? So, civil po pwedeng magkaroon. Okay. Two instances of determination of probable cause. So, dalawa. Di ba? Executive for purposes of filing the information. Judicial determination for purposes of the issuance of warrant of arrest. Okay? Magkaiba yung dalawang yan. Reyes versus Ombudsman, March 15, 2016, in bank. Now, judicial determination of probable cause shall be personally. Now, ano yung legal anchor? This is Article 3, Section 2 of the Constitution. No warrant of arrest or search warrant shall be issued except upon probable cause to be personally determined by the judge after examination under oath and affirmation of the complainant in this witness, particularly describing the place to be searched and the person to be seized. Okay? So, that is the legal basis. The reason why under the revised guidelines on continuous trial in criminal cases, motion for judicial determination is now a prohibited pleading. Reason, that is the primordial duty of the judge upon receipt of the information. So, reiteration lang. Kaya sabi ng Supreme Court, hindi na kinakailangan kasi yan naman ang duty ng judge. Okay. Now, can the determination of probable cause be based in case of determination by the public prosecutor, executive determination of probable cause? Pwede ba? Kasi napaka-dangerous class ng definition ngayon ng probable cause. Mere suspicion is enough. Hearsay evidence is admissible during preliminary investigation. That is the ruling in bank decision in the case of Estrada versus Ombudsman. The reason why gustong i-increase ang evidentiary requirement sa PI. So take note that even hearsay evidence, it's admissible during PI, but not during the trial. Kasi criminal cases must be based, or the conviction of the accused must be based on the highest quantum, which is proof beyond reasonable doubt. Okay. Punta tayo sa 113. Ang 113 shall be correlated with 126. Okay? So, no person can be arrested without a warrant. That is the general rule. Exception to the rule, Section 5 of 113. If in the presence of the police officer, the person to be arrested is actually committing the crime or about to commit or attempting to commit. Number 2, if the arresting officer has personal knowledge over the crime committed, and if you are a prisoner who escaped from jail. Kinapos ng oras, pwedeng tig-iisa lang. You can utilize in answering the question. So, ano yung una muna? In flagrante delicto. Okay? Ano yung pangalawa? At pursuit ka. Pangatlo, prisoner who escaped from jail. Now, is mere invitation equivalent to arrest? Again, this is a landmark decision. So, that is the case of Sanchez versus Demetrio. Matagal na. The counsel was Attorney Buddy Panelo, former presidential spokesperson. So, si Sanchez was suspect in the rape case of Aileen Sarmiento, sumalangit na kaluluwa. Inimbita, nakapanjama, dinala sa Laguna PNP, Provincial Command, hindi na pinalabas. So the Supreme Court said that mere invitation is equivalent to arrest. Now, insofar as the definition of the arrest, so the person is arrested to be under custody to answer for the commission of an offense. So you are arrested to answer for the commission of an offense. People versus Ambrosio, June 10, 2019. So paki-check nyo yung section 5. Paki-memorize by heart. Okay. Lifetime of a warrant of arrest versus lifetime of a search warrant. So the warrant of arrest remains outstanding until the accused is arrested. Now, search warrant, lifetime 10 days. After the lapse of the 10-day period, it becomes punctus officio. Okay. No quibbling, RTC, MTC can issue a warrant of arrest. Now, question, can an MTC judge issue a search warrant for violation of 9165? Now, the answer is yes, pursuant to the case of People versus Castillo. Because the word judge under Article 3, Section 2 of the Constitution was used in its generic sense. There is no classification whether you are an RTC judge or an MTC judge. Ano ba nangyari doon? The PNP in Tuguegarao applied for a search warrant outside of Tuguegarao, the municipality of Gataran. So after conducting a preliminary examination, the MTC judge issued a search warrant. When it was served, it yielded positive. They questioned the issuance for lack of jurisdiction. Ano sabi ng Supreme Court? Jurisdiction is not at issue in the application for search warrant. So therefore, even if for violation of 9165, which is punishable by more than 6 years, di ba doon sa Moya 3, sabi natin, 6 years pababa, MTC. But if for application of search warrant, hindi yun pinag-uusapan. Jurisdiction is not an issue. Okay? Now, extent of implementability. Search warrant or warrant of arrest can be implemented anywhere in the Philippines. Either issued by an MTC or RTC. Now, search warrant class is implementable only within the region. Regional in character. Exception to the rule. If applied by the director of the NBI in Manila, issued by the RTC, executive judge or vice executive judges of the RTC of Manila involving heinous crime. The same thing if it is applied by the director of the CIDG and issued by the executive judge and vice executive judges of Quezon City involving heinous crime, it is implementable anywhere in the Philippines. Okay? So take note of that, yung warrant of arrest saka search warrant. Now, bail, matter of right, if the crime committed is punishable less than reclusion perpetua or life imprisonment. Okay? Now, if it is punishable more than if it is punishable by reclusion perpetua or life imprisonment, matter of discretion. Exception to the rule. Even if punishable by reclusion perpetua or life imprisonment, if the evidence of guilt is not strong, you can still avail your right to bail. Question. How about if a case for murder was filed against A? A filed a petition for bail. During the bail hearing, the prosecution failed to prove the qualifying circumstance of treachery. Then it was denied. Does the court committed grave abuse of discretion? Answer, yes. Because without treachery, the case of A would only be homicide. So, titingnan ninyo. Now, arraignment, mandatory, shall be correlated with 118 Estipona versus Lubrigo. Plea bargaining kasi. Now, can arraignment be waived? The answer is yes, pursuant to the revised guidelines on continuous trial, provided that the judge is duty-bound also to propound questions as to whether or not the accused fully understood the consequences. So take note of that. Now, motion to quash under 117, Section 3, please memorize. When do you file your motion to quash? Before you enter your plea. How about if after you entered your plea, can you still file a motion to quash? Or are the grounds provided for under Section 3 waivable? Nakapag-enter ka na, pwede ka pa ba? The answer is yes. Please memorize A, B, G, and I. Exception to the rule. That even if you did not raise it during the arraignment, then it can still be raised after. A, B, G, and I. Okay? Now, kagang versus Sandigan Bayan. In addition to Section 3 of 117, in Kagang, nagkaroon ng panibagong ground. Okay? Na po pwedeng magamit na mag-file ka ng motion to quash on the ground of violation of your right to a speedy trial or speedy disposition of cases. Now, speedy trial applies only in criminal cases. Speedy disposition applies to civil, criminal, and administrative. When do you raise it? Now, sa Kagang class, ang sinasabi ng Supreme Court, which is an in-bank decision, you need to raise it first during the preliminary investigation. The period to conduct PI is provided for by Rule 112. And therefore, if it exceeds the period, it is the duty of the respondent to file a motion for early resolution. The failure on the part of the respondent to do so is considered as a waiver. Nagkaroon ng panibago na namang decision. Okay? July 28, 2020, Katamko versus Sandigan Bayan, 6th Division. Delay of the resolution for 2 years and 11 months and 12 days was declared inordinate. So, doctrine of inordinate delay. Please analyze the problem. So, if the period expired and no resolution yet has been issued by the investigating body, as a rule, you need to file a motion for early resolution. Now, how about the ombudsman? Kasi usually ang nagko-commit nito ang ombudsman. Now, how many days does the ombudsman have? Now, sabi ng Supreme Court, under Section 3F of Rule 112, the ombudsman has only 10 days from the date it is submitted to issue a resolution. After which, you can now file a motion for early resolution. Failure to issue the corresponding resolution, you can now invoke your right to speedy disposition in view of inordinate delay. Another decision, Mamansual versus Sandigan Bayan, November 3, 2020 by Mr. Justice Kagiwa. Yung ibang mga dinidiscuss ko, karamihan sa dinidiscuss ko ay nandoon na sa last minute notes ko na nasa Facebook, pwede niyong i-download, that is for free. Download nyo na lang. Okay, ito. What is blameless ignorance principle? Repeat, blameless ignorance principle. So, it usually applied in behest loan during the Marcos time, during the martial law regime. So, the Supreme Court in the case of Perez versus Sandigan Bayan, November 3, 2020 by Mr. Justice Kagiwa, that prescription runs only from the discovery of the crime. Not from its commission, but from discovery. Under the blameless ignorance principle. Pakitandaanan nyo, blameless ignorance principle. Okay, pre-trial mandatory both in civil and in criminal cases. Okay, now the pre-trial order class shall be signed by the accused and his counsel together with the public prosecutor. Once signed, then it shall govern the entire trial or the trial of the case. Okay? Now, period. Doon tayo sa trial. 999-90-90-90. On the part of the prosecution, he has 90 days to complete his presentation of evidence. 90 days also on the part of the defense to complete. And 90 days on the part of the court. Now, the 90-day period class for first and second level courts are provided for by Article 8 of the Constitution. Now, how about CA, Court of Tax Appeals in the Sandigan Bayan? They have 12 months if they are exercising their rights or power as an appellate court. But if they are exercising their jurisdiction or power as a trial court, 90 days lamang. Now, how about the Supreme Court? 24 months. Now, is the 24-month period mandatory for cases elevated to the Supreme Court to be decided? It is only directory. It was already, the 24-month period was already interpreted in the case of Inolba et al. Versus Justice Teresita Leonardo de Castro. The Supreme Court interpreted the 24-month period. Directory, hindi mandatory. So please bear it in mind. Okay? Now, judgment. What is the effect if the accused during the promulgation of as a requisite, the accused must be present during the promulgation. Exception to the rule, minor offenses, it can be promulgated in the presence of counsel. Now, effect if you fail to attend or to be present during the promulgation of judgment. Okay, your right to appeal is forfeited. The question is, can you regain your right to appeal? Now, the answer is yes, provided you reappeared within the 15-day period and explain satisfactorily to the court regarding your absence. Haylo versus Sandigan Bayan and people of the Philippines. Okay? So, pwede mong ma-regain kung magre-reappear ka. Because after the lapse of the 15-day period, the decision becomes final and executory. Okay? So, take note, na-discuss ko na rin yung search warrant. 127 shall be correlated with Rule 57. I-correlate ninyo because ang rule doon ay kapareho din sa Rule 57. Doon na kayo mag-concentrate because it is also applicable. Noemi, hanggang anong oras ako?
Hi po, Dean. Until 1 p.m. po. Pero we can proceed pa naman po.
O teka, extend mo lang ng kaunti ano. At
Okay po.
nakakaano namang mabitin yung mga natin, barista natin. Okay. Evidence tayo. Mabilisan. Okay, burden of proof, burden of evidence. Burden of proof never shifts. Burden of evidence shifts. Republic versus Borja. January 9, 2017, Mr. Justice Kagiwa. Okay? Now, what is the recognized rule in case the question is as to the credibility of the witness? Now, the observation in conclusion class of the trial court is given great respect and treated with finality. For the reason that it is the trial court who observed and who received the testimonial evidence. People versus Toreno. So this is Mr. Justice Kagiwa case. Now, as to the exclusionary rule, now, search incidental to a lawful arrest requires class that there must be first a valid arrest before search. The process cannot be reversed. I think lumabas din ito sa criminal law. The case of Picardal versus People, June 19, 2019. O baka ulitin. Now, judicial notice, okay, under 129. So, distinguish judicial notice, whether it is mandatory or discretionary. So, pagka discretionary, matters which are of public knowledge or are capable of unquestionable demonstration. Spouses C versus De Vera Navarro, April 3, 2019, Mr. Justice Kagiwa. Okay, judicial admission. So dalawang class ang judicial admission. Pwedeng verbal, pwedeng written. Verbal transpired during the trial or court proceedings in court. Written through pleadings. Agbayani versus Lupa Realty Holding Corporation, June 10, 2019. So pwedeng magkaroon ng tanong. Now, how about admission during pre-trial? Is it considered as judicial admission? Answer yes. So, during the pre-trial class, di ba nagkakaroon ng stipulation of facts? So, it means magpo-propose ka sa opposing counsel mo. Baka lang tanungin kayo. Will the defense admit that the accused was present on or about 12 midnight in the evening in Barangay San Nicolas, Iriga City, near the barangay hall? So, if the counsel for the accused admit, it is equivalent to judicial admission. So, take note of that. Now, sa 130 of, wag na kayong gagamit ng best evidence. Paalala lang. Because according to the U.S. Congress during the deliberation of the federal rules of evidence, where our rules were copied or patterned, the word best evidence is misleading. Kasi para kang naglalaro ng pusoy. Good, better, best. So hindi pala pwedeng best, pwedeng better. Hindi naman pwedeng better, good. So kung titingnan ninyo yung rules of court ninyo, kasi with due respect sa Rex and with due respect also sa Central, yung rules kasi hindi nila nilagay yung dalawang column, old saka new. Kaya pag bumili ka ng rules of court, akala mo walang nabago rin, wala naman nakalagay. Now, yung mga bago kasi class naka-underline. Kung titingnan mo yung old subtitle ng 130, number 1, nakalagay sa kaliwa, best evidence rule. Nakalagay sa kanan, original document rule. Kasi yan na yung bagong provision sa rules. Okay? So, po-promote ko lang, baka libre naman dito, yung sa libro ko, nakalagay kasi yon yung classification. Ako naglagay mismo, I dictated na kailangan ilagay natin because it took effect only on May 1 of 2020. Yung ibang estudyante nagtitipid din, wala silang pambili, pareho ko nung araw, o ayaw bumili, nasanay na sila. Okay? So, pagka lumabas sa problem, ang ilalagay nyo na original document rule. Now, what is the applicability of the original document rule? So, it applies only if what is as issue class is the writing itself. So, if it is only the existence of the writing or document, the original document rule does not apply. PISYO versus HRET. October, this is in-bank decision by Mr. Justice Kagiwa. Although, lagpas ito sa coverage. But hinabaan ko, ginawa ko until December 2021 yung mga cases na ilinagay natin. So take note of that. The original document rule is now, the best evidence rule is now the original document rule. Now, how about secondary evidence? What needs to be proved for the admission of secondary evidence? Okay? So one is loss or destruction of the original. Okay? Pwede yun. Now, proof of loss will be subjected to the less stringent standard if the best evidence rule applies. Okay? So it might be in the possession of the adverse party or it is voluminous in character. So the same ruling in PISYO versus HRET. Now, what is the effect if the offeror failed to justify the admission of the secondary evidence? Then In case of failure, it shall be denied admission. Because remember class, that under Section 34 of Rule 132, no evidence shall be considered by the court unless it is formally offered. Now, lulukso lang ako ng kaunti. Testimonial evidence is offered before the witness testify. Documentary evidence is offered after the testimony of the last witness. Okay? So, parole evidence rule, when the agreement between the two parties has been put into writing, it is the written document which is the sole repository and memorial of everything that they agreed on. So, hindi ka po pwedeng magdagdag. You cannot also exclude what was been put into writing and signed by the parties. Ang exceptions, apat ang ilinagay na exception. If there is an intrinsic ambiguity, the failure of the written agreement to express the true intent of the parties, when the validity of the agreement is at issue, and the existence of the terms agreed upon by the parties and their successor in interest after the execution of the written agreement. Okay? So, parole evidence rule. Now, how should the terms of the agreement between the parties be construed? So, the construction of the terms of the agreement class shall be interpreted which is most favorable to the party in whose favor the provision was made. Okay? Delgado versus GQ Realty Development Corporation, September 25, 2019, by Mr. Justice Kagiwa. Now, qualification of a witness. Is there political or educational attainment required so that you will qualify as a witness? Answer, no. Provided that the witness perceiving and can make known his perception, he is qualified to be a witness. People versus Magbitang. So yun lang ang importante sa witness. Okay, we go to disqualification by reason of privileged communication. Okay, so husband and wife, so one cannot testify against the other except for a case filed by one against the other. Example, 9262 or 7610 or adultery or concubinage. Sanchez versus Daruca, October 15, 2019, in bank decision. Okay? Now, admission and confession. Magkapareho ba sila? So, admission under Section 27. Confession under Section 34. Now, in confession class, there is an acknowledgement of guilt. No person will confess if he did not commit the crime charge. Okay? Whereas an admission is merely a statement of fact, not directly involving acknowledgement of guilt. So if you filed a counter affidavit, it cannot be considered as a confession, but it is merely an admission. People versus Likayan, February 28, 2002, in bank decision. So take note of that. Now, I have some problems which you can practice in my notes. Okay? Tingnan ninyo doon. Pati yung suggested answer. Okay? Now, admission by third party. Now, as a rule class, the admission of a third party will not affect whoever is mentioned in his admission pursuant to the rule or to the doctrine of res inter alios acta. Now, ano yung mga exception dito? Admission by conspirator. So the act of one is the act of all. Admission by previs. So if you are a party thereto, you are considered as privy. Now, remember during the PDAP scam, cases filed against Enrile, Senators Enrile, Bong Revilla, Jingo Estrada. So, admission made by Ben Hurluy. So, it was reconnected that it is also admission by previs and therefore admissible as evidence. Yung statement de Ben Hurluy. That leads to the conviction of JLN, Janet Lim Napoles. Now, admission by silence. Now, what is the applicability of the admission by silence? Now, the rule on admission of silence applies to adverse statement in writing if the party was carrying on mutual correspondence. Kasi class, kung verbal yan, kailangan sagutin mo agad. But if it is in writing, example, complaint affidavit or complaint of the plaintiff, di ba, in writing iyon. So there might be some delay, but it does not necessarily mean that there was admission in silence. If after the period given, you failed to file your comment or answer thereto or counter affidavit thereto, it could be considered as admission by silence. The reason why the information is filed. The reason why defendant is declared in default and the plaintiff is given a chance to present evidence ex parte. So take note of that. Now, testimonial knowledge. Yung section 22 class, kung makikita ninyo, kasi nagkaroon na ng sariling section yung hearsay. Now, before, nasa hearsay, ang walang exact section ang hearsay. Ang sinasabi lang, if you have no personal knowledge, then whatever your statement is considered as hearsay. Now, section 22, what is the evidentiary value of a newspaper article? So, it amounts to hearsay evidence twice removed and are therefore not only inadmissible but without any probative value whatsoever. Kasi yung newspaper, isinulat yun ng writer. Yung writer, kinuha lang niya yun sa isang tao. Kaya ang nakalagay, twice removed. Dalawa kasi ang involved. Ocampo versus Enriquez. August 8, 2017, in bank decision. This is the interment of late President Marcos before the libingan ng mga bayani. Okay? Now, ngayon, mayroon ng separate section class ang hearsay under section 37. So, sa section 37, what is hearsay? So, a statement, hearsay is a statement other than one made by the declarant. Okay, by the way, baka mamaya paggawin kayo sa forms, hindi na apayan ang ilalagay nyo. Ang ilalagay nyo na ay declarant. So, hearsay is a statement other than one made by the declarant while testifying at a trial or hearing. Okay? So, hearsay evidence is inadmissible except as otherwise provided by the rules. Now, what is a statement? So, a statement is an oral or written assertions. Pangalawa, non-verbal conduct of a person if it is intended by him as an assertion. So what are the elements of hearsay? A statement is not hearsay if the declarant testify at the trial or hearing and subjected to cross-examination. Okay, so as a general rule, all statements not made in court without the declarant subjected to cross-examination are considered hearsay. Now, it is removed from being hearsay if the declarant is subjected to cross-examination. Sarmiento versus Dizon, February 3, 2021, Mr. Justice Kagiwa. Okay, 13 exceptions to the hearsay rule. 1, dying declaration. 2, a statement of the decedent or person of unsound mind. Number 3, declaration against interest. Number 4, act or declaration about pedigree. Number 5, family reputation, tradition regarding pedigree. Number 6, common reputation. Number 7, part of res gestae. Number 8, recorded regularly conduct business activity. Number 9, commercial list and the likes. Number 10, entries of official records. 11, testimony or deposition of former proceedings, and residual exceptions, otherwise known as the catch-all exception. So, if it failed to qualify from the other hearsay, mayroong tinatawag na catch-all provision, otherwise known as residual exception. Now, bakit pala yung dying declaration ay exception sa hearsay rule? Ang sinasabi kasi, dying declaration clause is an evidence of the highest order. And it is entitled utmost credence since no person, ito ininterpret in a layman's language, no person who is about to die will tell a lie. People versus Antikla, October 17, 2018. Now, assuming class that it failed to qualify as a dying declaration, it can still qualify as part of the res gestae. People versus Mercado, October 17, 2018. So take note of those principles. Now, by the way, in the presentation of evidence class, all court now are utilizing judicial affidavit. So yung direct examination is now easy. Ang mahirap ngayon ay ang cross-examination. Kasi maski sa law school walang subject, and I am now advocating to offer that as an elective as I will be teaching at the De La Salle University College of Law. I propose to the dean to offer it as an elective subject in view of the development in our rules of procedure na nawawala na yung direct examination kasi nandun na lahat sa judicial affidavit. But in so far as cross-examination, isang section lang kasi. 132 section 6. But how to do it? Balibalik ta rin mo man yung buong rules of court, walang nakalagay dyan. Now, advantage and disadvantage of private and public document. Public document class are documents emanating from our government agencies, national and local government. Okay? Private document, if offered as evidence, you need to prove the due authenticity. But public document, you don't need. There is a presumption of regularity. Okay? Now, what is the second type of a public document? So, these are the notarized document. Okay? So, pagka na-notaryo yung dokumento, it forms parts of public documents. Exception to the rule. Last will and testament. hindi kasama yon na inire-report. Okay? It's already 1:30. I still have another lecture in one law school. So I want to pay goodbye to everyone and wish you good luck. At any rate, you can read my notes in cases in a question and answer format, including problem type. You can download it in my FB page. So dalawa yon, yung Salvador Moya II, saka yung attorney Salvador Moya II. Okay, so pwede ninyong i-download doon. And I wish to extend good luck to each and every candidate. And I will pray for you that you may reach the unreachable star. Now, as I always tell my students and reviewees, pray very, very hard as if it is all dependent to God. And study very, very hard as if it is all dependent on you. Okay, salamat sa PALS, salamat sa Rex Bookstore, okay, for the opportunity to share my little knowledge in remedial law. Good luck everyone and God bless you all.
Thank you so much, Dean Moy II, for your extensive knowledge on remedial law. For everybody watching, you may download all of the resources provided by Dean Salvador through his Facebook pages, as he mentioned. And thank you to our partners, Rex Bookstore and Rex Educampion, for making this event possible. We would like to remind everybody that our frequently asked topics on the bar subject lecture series is still ongoing. We still have legal ethics and special proceedings to tackle, so make sure to follow the PALS and Rex Bookstore Facebook pages for further updates. We hope that everybody tuned into our stream learned a lot from this morning's lecture. Thank you, everybody. Have a great afternoon, and we'll see you all tomorrow. Thank you, Dean.